Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not proven.
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Allegate commentary on the case. Dati mihi Anglican police service, but
That's literally not true.
oh, for crumb's sake.
Is that correct?
I didn't ask you to interrupt me.
Good morning. Welcome to the Court of Public Opinion. Happy Podcast Thursday. Happy Podcast Thursday to you. I am the Recovery Addict. It's great to have you all here with us, especially. It's great to have, come on. Why is that button? Why is this button not working this morning? I have to use that one. It's great to have Mindy FS777 with us. Mindy, congratulations. You were first in chat this morning. Quite prompt. Quite prompt, I might say. Yeah, because of your promptness, we're going to punish you. Everything IP related worldwide is your responsibility. You broke the stillness of the morning by chatting. So congratulations on good riddance. Internet's all yours today. It was by accident, I assure you, she says. Ignorance is not an excuse. You knew the punishment. I'm sure you did. All right. Welcome. Great to have you here. We're going to pick up where we left off in just a minute on the Virginia trial of Ebony Parker, which is wild. We'll talk about that. We left off in the middle of the day yesterday. We're still on catch up. Hopefully after the end of today, we should be all caught up. That's my goal. So buckle up. We've got a lot of work to do. But I don't know. My goal is to catch up before this trial ends in a mistrial. That's what I'm shooting for, because it looks like it's headed that way. And we'll talk more about that another time. Dr. Barry and Tony DeWitt are analyzing this trial. Oh, great. I cannot wait. I cannot wait to hear what people say. I didn't have a chance to even check anywhere else around the internet. But I'm sure a couple people have a few things to say about this trial, and we do as well. But first, thank you, Josh, by the way. Thanks. The mods had a great discussion this morning. They think I didn't see, but had a great discussion about the birthday list and other mod things. It was great to sort of follow along. Well, not also following along. Josh, thanks for putting the birthdays together for us. We have a happy birthday to Dan. It's a heavenly birthday. And Nomi, Larry, Sidetracks and Splinters, and Miss Joni Hockey, and Poppy. There we go. We've got them all. So, a few birthdays to sing to today, and by sing to, I mean all of us sing to, not just me. This is not a solo. I'm not a one-man show here. No, this is one of the world's largest birthday choirs is what this is, and you're a member. So please, wherever you are, if it's legal and you're able, stand up, take your breath, shoulders back, project your voice to the back of the room, blend your voice with the neighbor, and warm up with me if you will. La 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 la. That'll work. Sing happy birthday to these people before we start court. Happy birthday to you. Happy birthday to you. Happy birthday, dear Dan, Nomi, Larry, Sidetracks and Splinters, Miss Joni Hockey, and Poppy. Happy birthday to you. Woo! Barely got him in. Heavenly birthday to Dan, Nomi, Larry, Sidetracks and Splinters, Miss Joni Hockey, and Poppy. Happy birthday. I realize there are a million places you could be and a million people you could have celebrated with if you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn that joy back to make your day just a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Fastest ever. Happy birthday. Happy birthday. Oh, I didn't say the part about makes your day a little more special, but we do try to make your day a little more special. I knew I missed something in there. Dan would have been 32 today. Denisha, thank you very much for sharing that birthday with us. Let's all head to Tammy Dunlap's hotel. I think she's in Idaho right now on vacation. I'm drinking my breakfast this morning. through a straw. And before you at me for that, it's a healthy breakfast. It's a fruit smoothie. At least I'm calling it a fruit smoothie. You start with 4 big scoops of vanilla ice cream. Add some milk. You put in a couple pieces of fruit like strawberries, bananas, and then you blend. It's a fruit smoothie. So that's my breakfast today. Some people would call it a milkshake. I don't think so. Because it's got fruit in it. Janisha, no. Bear with me. It's a fruit smoothie. Drum solo. Here we go. Join with me. Air drums are great. Actually, I made a fruit smoothie for my wife. And it had like blueberries and raspberries and strawberries. We added a little bit of orange juice. High pulp orange juice, Simply Natural brand, not a sponsor. Add a little bit of vanilla yogurt in it. What else did I put in? I think that's about it. Just whatever I could find in the fridge and the freezer, and blended that all up, and it made this nice red puree, or like a deep purple puree. And I tasted that, and I said, that tastes like a superfruit. Now I'm going to make me one. And so I bust out the ice cream. Mine tastes delicious. I tell you, it tastes delicious. Regina Adams gifted 5 memberships. Thank you very much. All right, Jen Pookie says, can you summarize the lawyering in this case before we begin? It seems the prosecution is the only real lawyer here. I don't know. On paper, the judge has a stellar history. Like, she's got a lot of experience. And on paper, I think even the defense has a great history. They have, they've put in their time. They've worked in this field for a considerable amount of time. The judge having, most of her experience being before she took the bench in criminal trials. This is her first year. She's still inside her first year. I think she's under 10 months. She's like 9 months in to her first year on the bench as far as these criminal trials go. Her other judicial work was with juvenile court and family law. And those are different, but it's still in the same ballpark. I mean, you think. But she is... she seems a little bit like she's treading water and gulping for air at the same time, because she's made a lot better decisions, like on day 2 than she did day 1, where she had to look up definitions of hearsay and things like that. I think she's coming around. I think she was a little bit overwhelmed with the cameras and everything else in the courtroom, probably distracted a little as well. So... when it comes to the lawyer and the objection side, they're picking objections out of a hat, and by they I mean defense. And apparently the only 3 objections they have in the hat are hearsay, relevance, and leading. Now they've been using the leading one moderately well, with like 50% success, meaning they used it 50% of the time when it should have been, and 50% when it shouldn't. But the hearsay and relevant stuff has been crazy. And the judge initially ruling with them on a couple things that were just blatantly wrong, in my opinion. And the prosecutor, on the other hand, is a polished, seasoned professional, and obviously he's going for a guilty on this case. That's his goal. But he also is carrying the burden of teaching Law 101 to the judge, and by extension, the defense. So this has been just it continues to be a very interesting scenario that is playing out before us. Sort of law school, or early, first semester law school conversations mixed in with this legal battle over a scenario which really is quite unique, where you have an administrator in the education system, an assistant principal. I say vice principal because that's what we had growing up. They would call him that. But assistant principal who is accused of failing to act when information was brought to her that there was a possibility that a student had a firearm or a weapon or was dangerous, and didn't take any action. Well, the child did have a weapon. He did bring a gun to school. He did shoot his teacher. His teacher survived. Mrs. Werner, who raised these concerns, shared them with another teacher. The other teacher brought it to the assistant principal. Nothing was done in time. The child shot the teacher. She lived. She sued the school district and won $10 million in that lawsuit. The mother of the child has already been sentenced for making the gun available, or failing to secure the gun at home. And now we have a criminal case against this assistant principal for her failure to protect. It's negligence, child negligence, 8 counts, with up to 5 years sentence on each count. Could be concurrent, up to 40-year sentences max. Most likely would be consecutive, which would put it at a 5-year max, or 1 to 5 in that range. Anyway, that's where we are. 1 count for each of the bullets in the gun. Let's see. Thank you, Regina Adams, for gifting 5 memberships as well. Donnie, not Wahlberg, gifted membership as well. Appreciate that, Donnie. Let's see. I'm on the Cybertruck is not a boat trial watch. I saw that one. I saw the previews for that. Seems like a very expensive experiment to run on a vehicle. But let me tell you where we're picking up, because we are playing catch up. We are about halfway through yesterday right now, meaning the witness on the stand, Miss Ferris, I believe her name is. She is the HR administrator, and she has just been handed a copy of her full report to review, that the prosecution is then going to try to admit in as evidence after the defense has been asking her questions about what her investigation into this found. Susan CR gifted 5 memberships. Thank you, Susan. Appreciate that. Is there anything else I'm missing before we start? Josh says, I'm in charge of pins, but I'll pin them. Okay, sounds good. Thank you. I'll try not to mess up that whole system. I think we're already on day 2. Yes. And we'll be on day 3 here very shortly. So we're going to jump to court right now. And
yes. All right. So is that a fair and accurate copy of your complete full report of your investigation?
Yes.
All right, Judge. I move to admit that as Commonwealth's 3. I think.
Your Honor, I'm going to object. This is an investigation, confidential information, like investigation report that contains hearsay from other parties. It's not admissible.
Response.
The court's ruled otherwise already. Counsel has been allowed to elicit her opinion, the results of her investigation. Counsel has cross-examined her about the conclusions that are in that document. We have had a full interrogation about the facts found by her investigation and her conclusions. To not give the jury that document now is misleading. And so for the rule of completeness, the defense has been allowed to go in and talk about, cherry-pick little pieces that they want to talk about, and I'm seeking to admit the whole document so the jury can see it for themselves.
Ms. T?
Your Honor, we are on cross-examination allowed to ask about anything we want to ask about. It's launched in the scope of the direct examination. This is a report that contains hearsay statements from other parties, just as the court has ruled that the jury cannot consider the statements of other people that were mentioned in the video. Giving them a full report complete with hearsay is beyond the pale.
That's a good argument.
It's not useful.
Okay.
Report contains hearsay.
Of course, may I approach the the deputy has it. Yes,
please?
of course.
Thank you.
The judge asks to see the report herself. It's not admitted yet, but now she's reviewing this to see where this will go. It's a good argument to say it contains hearsay, and this would be a backdoor to hearsay, right? We're letting hearsay, other people's statements, into the jury through the back door. So, good argument by the defense. We've got to give them credit where it's due. She's a fast reader. That or she's just looking at the pictures. I don't know. She is flying through that. Wow. I think the defense did open the door to something coming in, but the hearsay.
Dr. Ferris has not been qualified as an expert.
So I'm going to count that as another objection, saying we can't bring her report in because she's not an expert. Usually reports don't come in, from my recollection, but
the court will allow a redacted version in, so I will sustain the defense objections as to some of this are not admissible based on the rules of evidence. The court's position is that page 1 and page 8 come in. So the cover sheet and the last page come in. The middle does not. I will remove the staple myself.
she's going to. I'll remove the staple myself. So we got the bookends of the report.
And
opening
the
closing.
Commonwealth wants the portion removed to be marked Commonwealth rejected.
Yes, please, Judge. Thank you.
Okay. Thank you. We're mad Kirk is amazing. Commonwealth, this we're at 3. Commonwealth 3. Rejected 1. Rejected Commonwealth 1. Okay, you may proceed with your redirect.
Judge, may I retrieve Commonwealth 3 from the court to bring to the witness?
Yes, and I'm going to ask. Yeah, I do.
I believe we are still in front of the jury right here.
Your staplers work just as good as my staplers. Oh.
For those that are counting, the number of sidebars we've had in this trial is still 0. We're just doing the speaking objection route instead, in front of the jury and everything.
For the purposes of these questions, I'll just ask you to refer to Commonwealth 3, which I have just handed you after it's been marked and entered by the court. There is a section on the second page of the 2 that were marked called Summary and Conclusion. Do you see that section?
Yes.
Could you please read it?
Yes. An investigation was conducted to review internal processes and establish if there were any deficiencies. From interviews, several employees were told that the student had a weapon. All instances were reported to Dr. Parker, assistant principal. An inquiry was made to Dr. Parker if the student could be searched.
Your Honor, again, I'm going to object to hearsay. Those are statements coming from other people.
You asked for the finding to be in evidence, the findings in evidence. So noted your objection, overruled.
Please continue.
The book bag was searched independently by Ms. Kovac. Permission was never given to search the student. At no time was the principal, Ms. Foster, notified of any communications about the student and the alleged weapon. Dr. Parker never left her office to investigate the situation with the student. Dr. Parker never spoke to Mrs. Foster, although they communicated about other school business prior to the incident. Dr. Parker admitted to handling a prior search situation with another student earlier in the school year, where she brought the student into her office to conduct a search. Although she says previous students' persons was not searched, she admitted that these students were pulled into her office to search their belongings at a minimum. This process was completed with the police or another adult present. Dr. Parker never left her office on the 6th to pull JT into her office. Dr. Parker responded that she could not leave her office due to testing as the reason for responding personally to the report of the student possibly having a weapon. Mr. Warner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and Dr. Parker all had knowledge that the student was in possession of a possible weapon before 2 p.m. Root cause: failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Lack of urgency and attention to multiple notifications. Lack of training and knowledge of the staff on how to handle this type of threat.
Thank you. May I approach the witness, Judge?
You may.
I'll retrieve Commonwealth 3 after this and return it to the court.
Thank you.
Now, Dr. Farish, previously when I was questioning you and then again with defense counsel, you were asked to read various sections of the Rights and Responsibilities Handbook, including that section on page 28 about principals and security officers under the direction of a school administrator may search students. Do you recall that document?
Yes.
All right, and that document is an authentic manual that provides all the policies that were in place at Rich Neck in the 2022-2023 school year?
The Rights and Responsibilities Handbook for the district for 22-23.
Yes, that's an official document of the district?
Yes.
Judge, I move to admit that document in whole into evidence as Commonwealth 4.
Not hearing an objection yet.
I will have to retrieve it from the witness.
Okay, you may approach.
Before that's admitted by the court, could I have a moment, please?
Yes, sir. You can still retrieve it, Mr. Jenkins, and you can pass it to Madam Clerk. I won't receive it until I hear from the defense counsel.
So this is the document with the search rules.
Oh, all right, so this will be marked Commonwealth 4.
May I approach the witness, Judge?
You may.
Dr. Farish, could you take a look at what I just handed you and identify it?
Yes, this is the Newport News Public Schools, Rich Neck Elementary 2022-2023 Multi-Hazard Crisis and Emergency Management Plan.
And is that a copy of the same document that you have that is the emergency management plan that I have asked you about and defense counsel has asked you about?
Yes.
Judge, I move to admit this in whole, unredacted, as Commonwealth 5. May I approach the witness?
You may.
I just want to make sure our objections continue.
Yes, continuing objection, which was previously ruled on and for the record was made contemporaneously.
And I have no further questions for the witness, Your Honor.
Thank you. Any recross?
Yes, Your Honor.
Okay, briefly.
So that was redirect. Now we're going to do a brief recross. It should be kept within the scope of the redirect. We'll see if they do.
Briefly, Dr. Farish. Again, the portion of the report that was just entered into evidence, your investigative findings, you were conducting that investigation on behalf of Newport News Public Schools, correct?
Correct.
Okay. As far as your findings, you were not assessing or giving up any opinion on whether Dr. Parker's or anybody or any other employee's conduct was criminal in nature, correct?
Correct.
You also mentioned in your root cause section of your report a lack of training and knowledge of the staff on how to handle this type of threat, correct?
Correct.
And you're referring to the staff as a whole, correct?
Correct.
And according to your report, all of the, I'll just name them specifically, Ms. Werner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and you say Dr. Parker, your finding is that none of them responded adequately, correct?
Objection, Judge. I think that misstates the evidence.
To respond adequately, I do think it's a misstatement. Can you rephrase?
Okay. All right. In your root cause section, you write, failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Does that apply to all of the people I just named, Ms. Werner, Ms. Kovac, Mr. Rawls, Ms. West, and Mr. Sims, and Dr. Parker?
Yes.
Okay. No further questions, John.
I have a follow-up, Judge.
Yes, sir.
In the root cause analysis section, is there a phrase that cites the failure to search?
Yes.
And according to the Rights and Responsibilities Handbook, what does it say about who may conduct a search specifically?
That was the one.
We took it away from you. Can I please retrieve Commonwealth's form? That's all right. The Rights and Responsibilities Handbook. And I can give you a page site. I'll direct your attention in Commonwealth's 5 to page 28, the paragraph that begins principals and school security officers.
Mm-hmm. Principals and school security officers, under the direction of a school administrator, may search students and student property.
All right. So, given the root cause analysis that involves the failure to search, who was authorized by the district's rights and responsibilities to search?
The school, under the direction of the school administrator.
Okay. And are teachers that work in a school considered school administrators?
No.
Are reading specialists that work at a school considered school administrators?
No.
All right, thank you. I don't have any further questions, please.
Okay, so this, so that paragraph, it starts out principals and school officers, and then it, comma, under the direction of a school administrator.
Objection. I object to counsel reading whatever he's reading from. The witness should be the one reading from the exhibit that the witness has.
Are you reading the same thing the witness has?
Yes, ma'am.
Okay, then go ahead. You may proceed overruled.
All right, so I'll read it again. Principals and school security officers, comma, under the direction of a school administrator. So would you agree that when it says under the direction of a school administrator, it's referring to somebody other than a principal or security officer?
The verbiage we use at the school district for administrator includes a principal and assistant principals. They are administrators.
Okay, but as this is read, it seems to indicate that they need to have the direction of somebody above them. Do you not see that?
Under the direction of a school administrator.
Principals? Okay. So if I take out it says principals, I can take out and school officers. So principals, comma, under the direction of a school administrator. So that seems to indicate there needs to be some authority above the principal. Do you disagree with that?
Same, Mr. Jenkins, the same. Next question, Mr. Rogers.
That's all I have done.
Okay. The status for this witness. May she be excused or does she need to remain sequestered?
I ask that she remain constructively sequestered, but of course able to be.
Mr. Rogers?
Yes, Your Honor.
We concur. Okay. All right. So, Dr. Fair, that means you are still a witness for purposes of this trial. You cannot discuss the case or discuss your testimony until you receive information that the trial is over. But you do not have to remain in the building or the witness room. You can go about your day, be available by phone if we need to call you back for your testimony.
Yes,
okay, and you'll be informed when you receive frustration ends and when you're released from the witness obligation. Okay, thank you, ma'am, and watch yourself as you step in.
Thank you.
All right.
The principal wasn't charged.
Another witness in about 10, or start with another witness about for 10 minutes or so. I just want to use up our time.
Before we call another witness, I would need to step out. So.
Okay, yes, Mr. Jenkins.
If we're going to need to take a break here, it doesn't make sense to call another. The break will take 5 minutes, and then we'll only have 5 minutes of a witness before one time.
So it is 12:51. We will start our recess for lunch. For the attorneys, are there any motions or objections that
go to
we
lunch.
need to take up before we resume evidence? Meaning, I'll tell the juries to report back at the jurors at one time, and I'll tell you all a different time if we need to work out issues.
There's nothing from the Commonwealth.
Okay, so they keep a tight schedule. Jurors report back at 2, attorneys report back at 2.
All right, we're going to skip ahead because we can, and we're on catch up, and we have a duty to be judicious with our time. In the interest of judicial expediency, we're going to fast forward through lunch yesterday because we are still on catch up. The reason the principal did not get charged in this as well is because the principal did not have the knowledge about what was happening involving the child. That knowledge only went up the chain to the vice or assistant principal and then stopped abruptly. So that's why there's only the assistant principal on trial. All right, let's jump back in. Lunch is over. Don't be, everyone take a seat. Here we go. All right. Just waiting for the audio to come back. Bailiff gets everything situated.
Resuming on day 3 after the lunch recess. Anything to take up before we bring the jurors out?
Nothing from the Commonwealth. We're good.
Okay, Chair, please bring out the jurors.
Please rise for the jury.
Probably the strangest thing I've seen in this court that the judge seems to allow and not know that she can prohibit is the 2 riders on 1 horse. Defense will literally tag team a witness, one person asking a long series of questions, then tagging the other person in for them to ask their questions. Never seen that before.
14 jurors in the box.
All right, thank you so much. You all may have to take your seats.
I think he has a medical issue.
Jurors in the box. And to the jurors, are there any issues to report to the court? Okay, nothing has been said. All right, next witness, Mr. Jenkins.
The Commonwealth calls Mark Garcia.
I heard the name Mark Garcia or something similar to it. I'm also surprised we still have 14 jurors in the box. I've got this one on my currently. I'm where I am on this trial. I think it's like a 50% chance it ends in a mistrial and 50% chance it ends in a mistrial. I'm sorry. I don't know how this is going to get to the end. It just seems to be such a train wreck that veers back and forth. Somehow we managed to recover our footing back on track. It's wild.
Good afternoon. Come stand in front of Madam Clerk, please. Raise your hand.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Okay, sir, take a witness stand, please. Watch your step. Okay, adjust the microphone and please answer questions the attorneys may have.
Good afternoon, sir.
Afternoon.
Would you please tell us your name?
Mark Lincoln Garcia Sr.
All right, sir. And I know that I mentioned this to you earlier, but just as a reminder, we're not saying the names of any children at all today. You're welcome to use initials or refer to them, like my son, for example, but no names. I want to, do you have a son?
Yes.
And what is his initials?
MJ.
All right. Did MJ attend Rich Neck Elementary School?
Yes.
Was MJ in attendance at Rich Neck on January 6, 2023?
Yes.
How old was he then?
7.
On January 6 of 2023, did you go to Rich Neck Elementary School? Well, first of all, let me ask you this question. Did you take MJ to school?
Yes.
So was that in your car? Did you personally drop them off?
Yes, I drop them off every day.
Okay. And on that day, did you go back to Rich Neck Elementary School sooner than you normally would?
Yes.
When you arrived there, I want you to describe what you saw occurring without telling me what anyone was saying.
Okay. Well, getting there was a task because once you get to Jefferson, going down Rich Neck, it was kind of like cordoned off by the cops and a lot of people trying to go there. So we had to go to the adjacent road, which is Monroe. And we had to come down Monroe, and we got to Monroe and we had to stop because there's a lot of cars. So I parked my car in somebody's house, and they said we could park there. And I got out my car, and I parked my car, and I went down the road, and there's a church that's on the right-hand side, and that's where everything was cordoned off by the cops, and that's where all of the confusion was going on because nobody knew what was going on.
So did you go to that church area where people were gathering?
We were in the middle of the street.
Okay. And did you immediately see MJ there?
No.
Okay. From the time you arrive, and I know I'm asking you to estimate, but can you give us an estimate? Are you able to give us an estimate of how long it was from the time you arrived at Rich Neck to the time you saw your son?
Objection. Response.
This is the connection, Judge, that we have been talking about in this case between the shooting and the ensuing trauma to the children, and that came from a delayed reunification, and that came from, as we will hear in a moment, that came from the continued chaos leading to these children in a panic and a state of trauma.
Your Honor, I'm going to continue to object. Even his response to this is a narrative testimony in front of the jury.
What's the nexus to why we're here? And I guess I'm missing that. If you can found the fact, if not, it's sustained.
Object to the response is a narrative.
The nexus for why we're here. Let me look at the statute and read from the statute.
There's some statutorial support for what the prosecutor is doing, but I don't know if it's strong. The judge has already indicated
18.2, 371.1. Any person responsible for the care of a child under 18 whose willful act or omission in that care was so gross, wanton, and culpable to show a reckless disregard for human life is guilty of a Class 6 felony. As to how
A delayed reunification.
The shooting,
Yes.
Judge, the shooting occurred, and everything that has happened to these children is a follow-on from the shooting that establishes it is gross, wanton, and culpable behavior of Dr. Parker. It was the willful omission that caused these children to be separated from their parents in a state of chaos.
I sustain the objection.
I like that from the judge.
Next question, please.
That actually chops a huge chunk of the state's case out.
Mr. Garcia, after you were reunited with your son, describe his demeanor, how he looked to you.
Objection again, it's irrelevant, Your Honor.
He can describe that out loud. Overruled. You may answer the question, sir. Do you need him to repeat it?
Okay.
Demeanor may lend to...
My son looked confused. He was very scared and very shocked that all of this took place in his school, in which he loved.
All right. And are there any ways that you've noticed as a parent that your son is different was different after the shooting versus before the shooting?
Yes.
Describe what you noticed.
Objection.
And objection to relevance.
Okay, I didn't hear. Okay, leading and relevance.
Two
He
different...
can describe what he observed when he sees his son. Go ahead. Overruled.
So, my son, he's in therapy. He has to go to therapy now. He's still scared of the dark areas in which they have to be pushed in their safe room. He's not comfortable in certain situations like he used to be, like being talkative and things of that nature.
Objection, Your Honor. If I can just throw questions out on you.
Yes, sir.
Even regarding the statute, the things the Commonwealth has to prove, this is the things that he's testifying to is not a material fact that has to be proven or established to prove that Dr. Parker is guilty of this crime. He's testifying as to things that occurred afterwards, but nothing regarding Dr. Parker's conduct or lack of conduct. So it's not relevant.
Response?
Child abuse and neglect requires a showing that the abuse is so gross, wanton, and culpable that it showed a disregard for human life. The effects of the abuse are what he is testifying to. That is what is gross, wanton, and culpable. And we're there. This is as far as I'm going with this. But the fact that the child is different after than before is relevant to whether the choices Dr. Parker made were gross, or the omissions were gross, wanton, and culpable, because this is the after effect to the children.
It can end here, but again, I'll let you finish, Mr. Rogers. But as to where we are now, I'm going to overrule the defense objection. You can ask that one question. The gentleman may answer that question, but then we're going to stop. Yes, Mr. Rogers.
Just for the record. Your Honor, I might agree with Mr. Jenkins if the Commonwealth had to prove some type of serious injury, but that's not what is charged. It's felony abuse and neglect, but it's not based on any injury. It's based on my conduct and not any impact on these children.
Anything additional?
Not from me, Judge.
Okay. Do you need the attorney to repeat his question?
Yes, please.
Okay. How was your child different after the shooting versus before?
Yes.
Describe how he was different after.
Would you like me to describe before?
If you
had to answer the question that he asked.
Okay.
Yeah.
So after, again, my son, he doesn't like sleeping in the dark because of being in that safe room for however long they were in that safe room, being confined to an area, having, I don't know how much light it was, but he's scared of the dark, having added more light and going to therapy.
Okay. And were any of those things present prior to the shooting?
No.
All right, thank you. I don't have any further questions for you.
Good afternoon, Mr. Garcia. I just have a few questions. Are you familiar with any relationship that your son had with Dr. Parker?
No.
Okay. Your son was a second grade student at Rich Neck, correct?
Correct.
So he was not in Ms. Werner's classroom, correct?
No.
Okay. You mentioned something about a safe room. Isn't it true that your son was in the gym?
No.
Your son was not in the gym when you picked him up?
No.
Okay. Where was he?
I don't know.
Oh, you don't know?
No, we were told by the police.
Oh, well, I'm not asking you to tell me what somebody told you.
Okay.
So you don't know?
No.
Okay. You filed a civil lawsuit arising from the events on January 6, 2023, correct?
Correct.
Okay. And it's filed here in this courthouse, correct?
Not sure.
You're not sure?
No, I did. You have to talk to my attorney on that.
I'm sorry?
You have to talk to my attorney on that.
Okay. You have named Dr. Parker as a defendant in your case, your civil case, correct?
Correct.
And you're seeking money damages from Dr. Parker, correct?
I'm not going to talk about that on camera because it's streaming.
Judge, I am going to make a limited objection here in that any civil suits relate to the children, and I think what he's requesting is that we not be on the air for this discussion and the cameras not continue recording while he discusses his child, and I support that request and ask the court to do that.
Response?
Well, Your Honor, he just asked a series of questions about the child on camera. I'm asking about a civil case, asking him whether he filed a civil case. It has nothing to do with the child himself.
So the objection is overruled. Cross-examination, the questioner is allowed to examine the witness's interest in a case. And for the witness, we are not using names, we are using initials as we previously did. So that is the protection to minors in this case. All right, you may proceed, Mr. T.
Mr. Garcia, you are seeking money damages from Dr. Ebony Parker in that civil case, correct?
Yes.
And a criminal conviction of Dr. Parker would assist in your civil case against her, wouldn't it?
I believe so.
Okay. So you have a financial interest in the outcome of this criminal trial?
Financial? What do you mean?
Well, you just stated that you believe that a criminal conviction of Dr. Parker would assist you in your civil case where you're suing for money, correct?
Yes.
Okay. So you would agree you have a financial interest in the outcome of the criminal trial, correct?
Possibly, yes.
Okay.
That's why you wait to file your civil suit till after the criminal suit. Then you don't have these awkward questions.
When did the school first contact you about the shooting?
January 16th.
16th?
Yes.
Okay. So 10 days after the shooting occurred. Okay. And how did you get that notification?
I was called by the city, the Newport News Public Schools, I forgot the name of the downtown director of people, but I know her name is, I know her name, but she called me at 6 o'clock on the 16th.
Okay. And do you consider that failure to notify you for 10 days a failure?
Absolutely.
And do you believe that failure is on the part of Newport News Public Schools?
I believe it's on the part of the school system as well as Newport News Public Schools.
Thank you. No further questions.
Any redirect?
Yes, Your Honor. You've indicated on cross-examination that your son, MJ, was not in Miss Werner's classroom. What was his homeroom?
His homeroom was Mrs. McAulif's class.
And did he have occasion to interact with other students from other classes?
They were in the same hallway.
Now, in the immediate aftermath of this, when you picked him up, did he tell you anything about contact he had had with another student?
Objection, relevance, and hearsay.
Okay, and I was going to ask you, are you asking me to give the statement or just to?
I am going to attempt to establish possibly an excited utterance.
That's
Okay, all right, so there's an objection.
Yes.
What's your response?
What is the legal basis for the objection? I missed it.
If you can repeat, Mr. T.
Relevance and hearsay.
Okay.
Excited
So
utterances.
it would be hearsay unless the court finds that the excited utterance exception applies. I'll need to lay a foundation for that.
Law School 101.
So you can lay a foundation and to the witness, sir, when we ask you to pause, and we can make sure that the evidence is appropriate under the rules of evidence. You may proceed.
In the immediate aftermath of the event, right when you see your son, does your son speak to you about the event?
Yes.
Does your son tell you about a child he interacted with that day?
Yes.
Okay. And do you know who, just a yes or no question, do you know who that child is?
No.
Okay. When your son is telling you this, can you describe for us, without saying what he said, can you describe his demeanor, how he appeared and how he was acting, and how he sounded?
He was scared, shaky, and nervous.
Okay. Did he relate to you something that had just happened earlier that day?
Correct.
Judge, I think that is sufficient foundation for as to hearsay under the excited utterance.
Yes, sir. Anything from the defense?
Yes, Your Honor. He has, Mr. Cumberland has not established any foundation regarding excited utterances. We don't know how long before, and if we're talking about the shooting that had occurred at 2 p.m. and the father didn't pick up his child until sometime later in the afternoon, presumably hours later, then I don't see how it qualifies as an excited utterance.
And with defense on this one.
May I respond to that, Judge?
Yes, sir.
The excited utterance exception is extended when the declarant is a child, because courts have recognized in Virginia the nature of being a child and brain development means that the heightened experience of an emergency extends quite some time. There are cases that I will have to look up if the court would like that involve many hours long when the child is young. The younger the child and the more traumatized they are acting, the longer the extension of the excited utterance is.
I didn't know that.
I am going to sustain the objection. The legal basis would be as such. Reading Rule 2:803, excited utterance. So an excited utterance is defined as a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with first-hand knowledge at the time under circumstances negating deliberation. Again, my pauses are to show the pauses and breakups and how to decipher that. It has not been established that the declarant, which would be the witness's son, had first-hand knowledge at a time, as he was not in the affected classrooms, and there's been no evidence other than that being a student at school since it happened, as to how he would have gained first-hand knowledge through an appropriate way. So I'm going to sustain the eviction.
I'm going to request to voir dire the witness so that I can establish exactly that.
Okay, and you're asking to do so out of the presence of the jury.
Yes, Your Honor.
All right.
All
Ladies
right.
and gentlemen, if you kindly retire to the jury room and we'll bring it out as soon as we can. Thank you.
Please rise to the jury.
I don't like where the prosecutor's going. I think he might be able to do it successfully, but I don't like where he's going. We have a child in another classroom whose parents are suing the school for the trauma they experienced by he had to be in a safe room. And had delayed separation from the parents. There's no limits to what they can include here.
In that moment where you were just describing his demeanor, tell us what MJ told you.
That my son sits on the last seat because they don't have any doors in their classroom. So his seat, he could hear the pop. When he heard the pop,
okay, that's different.
The teacher, they heard over the walkie-talkie that someone got shot. And they got everybody scrambled into the outside of their classroom, which was in the direct line of supposedly their safe zone, which is outside of their classrooms.
Okay, let me ask you this question. Did MJ say all of that to you in that moment?
Yes.
Okay. And so, if I understand your testimony correctly, is it that he heard the gunshot and he was in a classroom that had no door?
Yes.
Okay.
He heard a pop, I believe.
A pop.
Yes.
Testimony was.
And then he had to evacuate with the school, basically.
He had to evacuate his classroom in the danger zone.
Okay.
Say that you're saying in or and the danger zone?
In the danger zone, because his class has no door, so the zone of where they have to go out is outside of their classroom in that same hallway.
Okay, and he used the word danger zone.
My son?
Yes.
No.
Okay, I think he's asking you what did the child say? I mean the verbatim statement.
He was in his the safe room. He went to the safe room.
Okay.
Okay, you're calling it a safe room. You're calling it a danger zone. He's calling it a safe room.
I was going to address his characterization of danger zone that he recorded.
Continue with your
Judge, I'm not going to seek to admit the statement. We need to bring the jury back up. Thank you, Mr. Garcia.
And I know you all just stood. You can keep your seats this time. And I'll explain to them. I gave you a break. It was just a few minutes ago. You can bring them out today. Everybody doesn't have to stand. You're all welcome to have a seat once everyone comes in.
14 jurors in the box.
Thank you very much. Okay, jurors have a seat. And normally they stand. I told them that they just stood. They didn't have to. So it's no disrespect to you all. It was just my command. You may finish with your questions if you have any more.
Yes, Your Honor. Mr. Garcia, had you personally ever been inside Rich Neck Elementary School?
Yes.
Had you personally ever gone to your son's classroom?
Yes.
And did your son's classroom have a door?
No.
All right, thank you. I don't have anything further.
Son's classroom didn't have a door.
I think we're fine.
Defense has no questions.
No question.
Okay, all right. And the status for this witness?
I would ask that he be released unless there's an objection to that.
He can be released, Your Honor.
The state said, we want all our witnesses kept on. And now they're releasing half of them.
Thank you, sir.
Thank you so much.
I think they had a doorway, just not a door to close.
Commonwealth will call Susan White.
Susan White?
Susan White.
Thank you.
They had to leave their classroom to go to a safe room because their classroom didn't have a door to secure their classroom. Boggles the mind. I don't like where the state's going with this. I think the breadth and scope they're trying to wrap into under this umbrella of
Do you swear
the
affirm the
charges
testimony you're about to give is the truth, whole truth, and nothing but the truth?
seems excessive.
Your Honor, if I may.
Yes, sir?
The charges themselves are.
Mrs. White's.
Okay, come on, hold on one second. Come on in the witness stand and watch yourself. Yes, you can move the chair and microphone. Yes, Mr.
The court's already ruled on Mrs. White's ability to be able to testify today. Pursuing my objection to any testimony that she may give regarding how it's not relevant to what happened on January 6th regarding my client's conduct in the actual admission that occurred on there today. She can't testify to that because she didn't observe it. So I don't believe that she has anything of relevance to offer the.
I object to this witness.
If my client's conduct is appropriate.
So noted. Thank you. You may proceed, Mr. Chairman.
Good afternoon. Tell us your name.
Susan White.
Ms. White, how are you employed?
Right now I'm retired.
And on January 6th of 2023, how are you employed?
I was retired by then too.
Okay. And were you at Rich Neck Elementary School?
Yes, I was.
Why?
I was there for 34 years.
Okay.
And my last year was the year before
Right.
that happened.
And so I want to take you back to the year before that, which was that your final year before retirement?
It was.
Okay.
No, I'm sorry. I don't believe her answer was responsive to the question. There may have been a misunderstanding as to what was asked. So it definitely wasn't.
Are you objecting to your own question?
Clear that up on cross-examination. You may proceed, Mr. Jenkins.
So during the course of your last year of teaching at Rich Neck, did you know a student who we're referring to as JT?
Yes, I did.
Okay, and as a reminder, we're not speaking the names of any students at all, only using initials. Whose class was JT in?
My class.
And what grade was that?
Kindergarten.
Okay. During the course of your time with JT, was there ever a discipline incident that you did report directly to Dr. Parker?
Yes.
I want you to start at the beginning of that incident that you eventually reported. So what was going on that day that began that?
He had gone up. This was during post-COVID, so we had to be careful with distances and with masks. And he'd gone up to the front of another child's desk with his chair and put his face over about 3 inches from the other child's face. And so I had to think, what am I going to do about this? Because just telling him no, or you need to get back to your seat or whatever, those weren't working with him. So I slid the chair slowly so that if he wanted to get up, he could get up. And if he didn't want to, he could stay seated. I was going to bring it to his desk. But then he pulled the legs away and dropped them. And so I brought it up a little bit further just so I could be right in front of the class. And I sat there and I kept on teaching. Okay. So I was still talking with the students.
Let me pause you for a moment so we can kind of visualize the scene. So when he is in the face of another student, how is he? Is he sitting, standing, or doing something else?
He's sitting, leaning in toward him, staring him in the eyes.
Okay. And you testified that you pulled him away. Could you describe how you did that?
I slid the chair I was holding the back of the chair, and I slid it back. We had no carpets at that time because of COVID, so it was easy enough to do.
Yeah.
And so he hopped
their
up and
carpet?
grabbed the front legs of the chair and pulled them forward. But I was able not to fall, but to still hold on. So I could get it a couple feet further, and I just sat on it.
So when he pulled the legs, had he stood up out of the chair?
Yeah.
Okay.
Oh, yeah.
So what happens after that point?
I was sitting in the chair, and I was talking to the class, and not about behavior, about the instruction we were doing. And he walked up behind me and put both of his arms in front of my throat and locked them together and pulled back and down hard. I couldn't breathe. And he didn't let up on it. The only way I got out of that situation was the assistant, the teacher's assistant that I shared with another teacher, happened to be in there at the time. She was in the back of the room. So she came up and pulled him off with me and took him out of the room. But until she pulled his arms off, I couldn't breathe.
What, if anything, happened with JT immediately after that? Does he remain in your room?
No, I wouldn't have had it. I would have left if he did. No, Mrs. Perger, my assistant, took him out of the room. But then, sometime later in the day, and it got very blurry after that for me, so I can't tell you how long. One of our counselors and our security officer came and brought him back to my room.
So when you say, hold on, when you say brought him back, do you mean JT?
Yes.
Okay.
Yes.
So when
they
you
each had him, I'm sorry.
When you see him come back to your room with the counselor and school security guard, what happens?
They each had him by one hand, and they were trying to get him to move into the room. And he was yelling, no, I don't want to go back in the classroom. And I looked at them, and I had his back to the doorway so I could talk to them without everyone in the classroom hearing. And I said, well, he's right. He does not belong back in the classroom. What he did was severe enough for me to contact the police and to press charges. And the security officer agreed with me.
Okay, so what happens with JT next?
Well, they told me they were bringing him back to me because no administrator was available to handle the situation.
Okay.
So I said that if he was going to stay in there, I was going to need to leave the room.
Did you in fact leave the room?
I did, but not because of that. I believe they took him back out again, but it's very fuzzy.
Okay.
What I know is by that point I was so shaky that Mrs. Perger, my assistant, said, go ahead and take a break. And I took my laptop and went to the lounge and got the incident referral form because I wasn't going to leave school without reporting that.
Okay, so hold on just a minute. Mm-hmm. You've mentioned an incident referral form. Can you just kind of explain to the jury what that is?
That's if you think the discipline problem is dangerous enough or bad enough that you need to refer them officially, formally, to the administrators.
And when you say the administrators, what titles do you mean?
Assistant principal and principal.
Okay. And who was the assistant principal at Rich Neck Elementary School at the time that this happened?
Dr. Parker.
And is Dr. Parker in the courtroom right now?
Yes.
Could you just point her out, please?
She's right there.
Okay. Will the record reflect that she's indicated dependent?
I was not. Can you point her out again? I didn't see your hand. All right. So noted.
Thank you, Jim. So you've told us that you got an incident referral form, okay? And what did you do with it?
I filled it out and I typed up a whole description of everything that had happened that day because I had had some positive moments with him earlier, so I wanted those included too. So typed up the day, and then I
attached it to the referral form as the attachment and the explanation of the behavior. And then I went to the office and I saw that Dr. Goodman, the principal at the time, and Dr. Parker, they were in her office at the time.
And did you go into the office?
I went into the office. I told them everything that had happened.
Let me ask you this question. Did you have the incident referral form with you?
I had it in my hand.
Do you know who you handed it to or what you did with it?
I handed it to Dr. Goodman after I explained everything on it to both of them.
I understand. So after you explained everything that was on it, did, if you remember, did Dr. Parker or Principal Goodman react to that in any way? And if so, how?
Dr. Goodman did. When I was talking about the fact that if an attack is occurring, it should never be that no administrator is available to help with it unless there's a worse attack going somewhere at the same time.
Okay. Did Dr. Parker say anything or
no,
have
she was making eye contact. She was looking at me. She didn't say anything.
Okay.
Dr. Goodman said, sort of under his breath, prioritize. And I thought, well, yeah, that's what I wanted him to get from that. And then he told me to go to the nurse and have my neck checked out afterwards.
Okay. That year, did JT ultimately return to your classroom or not?
He did.
Okay.
He returned the very next day. He walked in with his breakfast.
Okay.
And I immediately went to the teacher across from me and said, I need to go to the office so that she would watch both of the classes. And she saw who I had with me, and so she understood. And I just told him, he had his breakfast with him. I said, just bring it and come with me. And so we went to the office and I had him sit down in the waiting area for parents there. And I went into Dr. Parker's office, and I knew at that time that my assistant had to stay in a first grade class all day because the sub hadn't showed up. So I would not have another adult in the room. So what I told her is, I cannot be the only adult in the classroom if he's in that room. And so either he needs to be somewhere else or I'm going to have to take a sick day and go home.
And was he relocated or what happened?
He must have been, because I went directly back to the classroom and continued teaching for the day. I didn't see him the rest of the day.
Okay. At some point later in the year, does he come back to your classroom?
No.
Okay. If there were, and if you remember, any other discipline incidents you saw yourself and you reported to Dr. Parker yourself, are there any such incidents?
With him?
With JT, that's right.
No, I don't believe so.
Thank you so much. I don't have any further questions for you. Please answer any questions of the defense counsel.
You have a moment?
Yes, sir. I'm sorry.
Okay. Are you all right?
Yeah, I'm okay. I thought he was asking me.
I'm sorry. It's a moment to confer.
The school policies were designed to find solutions that would keep troubled students in the classroom to some degree, to continue the education process, to keep them involved and incorporated, even if it took major workarounds to accommodate troubled children. That was the goal of the programs. So this child already had a special plan, a special program. Only spent, I think, about 2 hours out of the day with his regular class, is my understanding. Had support programs in place, people that would take him from one area to another, special tutors and teachers. It was inclusion for sure. Possibly too much.
Hello, Ms. White. You just testified that you reported JT's behavior or his presence in your classroom to Dr. Parker directly when he came back the next day, correct? Mm-hmm. Okay. And then when you told her that, after that, he never appeared in your classroom again, correct?
Right. And I heard, but...
No, you don't tell me what you heard.
Okay.
So when you told her that action was taken and justice was JT was removed from your classroom.
He messed up.
He went to another school.
Okay.
Messed up and forgot the initials. That's the second time they've slipped,
All right.
given his first name.
Regarding the incident referral that you mentioned, do you know whether Newport News Public Schools retained a copy of it?
I was told they didn't.
Okay. And did you have to then supply it to someone else, your own copy that you maintained?
Yes.
No further questions.
In brief, direct.
Yes, Your Honor. Ms. White, I want to just direct your attention to the incident referral form. You've indicated there was a form. Was that the only piece of paper you submitted?
I submitted the referral form with the attached description of the day.
Okay.
So that I could get the full explanation of what happened, because this little place is not going to be enough.
Understood. And the a description of the day that you attached to the referral form, was it typewritten, handwritten, or something else?
Typewritten.
All right. If I showed it to you, would you recognize it?
Definitely.
May I approach the witness, Your Honor?
You may.
May I see the exhibit?
You may.
Sure.
There does seem to be a strong correlation between children who have significant troubles at home and children that have troubles at school. But just because a child is disruptive at school does not mean they're troubled at home. It's not equal across the board. Sometimes you have children that were given every chance and opportunity at home, and for some reason choose different routes. I know I wasn't the easiest kid, and I had great parents. So I didn't fail my first class till 4th grade, though. I count that as a win.
May I approach the witness, Your Honor?
You may.
The correlation's there. I mean, it's you can't deny the correlation. It's present, but it's
What is it?
one
What
to
is
one.
it that I paid?
You handed me the detailed description that I attached to the incident referral form. And
Okay, and is what you're looking at now a true and accurate copy of the incident report as you wrote it?
yes.
Has anything been redacted from it?
Well, yeah, but I did that myself for some that I gave to other people.
What was redacted? Is it a category? I don't know. I sort of words. Is it names?
Names.
Hold on one second, ma'am. Yes, sir.
Before she even answers that, objection, that document is hearsay. It's an out-of-court statement. It's written, being offered for its truth of what happened on that day. She's testified as to what occurred. She's testified that she produced this incident report, but as far as the contents of that incident report, I'm objecting to it as hearsay.
The objection is premature. I haven't offered it as evidence yet.
Agreed, premature, not yet right. You may proceed.
How embarrassing, premature.
The redactions
objection.
that appear are the redactions that you did.
The names, yes. I don't know what I had at the top.
Okay. Are you sure that that is the incident referral that you submitted attached to the form?
It looks like it.
Okay. It either is or it isn't. Take your time to read it.
Yeah. I was going to say I write a lot, but yeah.
So is it the incident referral?
Mm-hmm.
Is that yes?
Yes, it's the attachment that I attached to.
Thank you. Judge, I am moving that now into evidence as Commonwealth 6 as a past recollection recorded, for one thing, and also as a prior consistent statement, because the defense was alleging that or suggesting that it didn't exist, essentially, in cross-exam.
Whoa. It's a bold allegation.
Your Honor, there was no such insinuation that it didn't exist. So that's number one. It's still hearsay. Is duplicative of her testimony and all the previous objections that Mr. Rogers lodged.
All the objections.
And it goes beyond, I'm sorry, it goes beyond my redirect as well. I mean, my cross-examination.
And also, how is this not bolstering? How is this permissible bolstering? She testified to what she recalled happened, I think it was a year before?
Yes.
So, I'm talking to the attorney.
I'm sorry.
She testified to what she believed happened to her a year before. Why are we allowing in her written statement, her redacted written statement about that?
Because defense counsel asked whether she gave it to the schools and whether it still exists. And I'm establishing that it does.
Okay, so I guess you're interpreting that as an attempt to impeach. And so you're trying to rehabilitate?
If the objection is hearsay, there's an exception to that. If we want to talk about why it's relevant at this stage, yes, we can go to the relevance rules and find that a prior consistent statement does become relevant when on cross-examination, or does become admissible when on cross-examination the witness has been challenged as to having a memory or forgetting something. I could find the rule.
Prior consistent. I understand that's where the impeachment can't come in, but that's the missing link for me. So saying it does not come in, and you may approach to retrieve the document.
Thank you, Judge.
The judge has golden wings. The light falls just so. Thanks for no spoilers in chat.
Thank you. I
appreciate that.
Anything further? Okay, and the status for this witness?
We're well aware of what's happening. We like to be here in the moment.
I'd ask you to release.
Okay, and no objection from defense. Okay, so that means thank you for your testimony today. You are released as a witness. You don't have to go back to that room. You do not have to stay in the courthouse. You are welcome to remain in the courtroom if you'd like. Okay, then watch your step in. Thank you very much. Next witness.
Commonwealth calls for Alonzo Rawls.
Let's not talk about the moderator actions. Those get dismissed as spam as well, so they fall in the same category. It just makes the mods work harder when you talk about things they're doing in chat.
Raise your hand, sir. Do you swear or affirm the testimony you're about to give is the truth,
Please take the witness stand, sir. Watch your step, and you can adjust the chair and microphone as you need. You may proceed.
Good afternoon.
Good afternoon.
Would you please tell us your name?
Alonzo Rawls.
Mr. Rawls, just a quick reminder that we're not using the names of any children today in court. We'll use initials in place of that. Mr. Rawls, in January of 2023, how were you employed?
I was a school counselor.
Where?
At New Plymouth Public School at Richmond Elementary.
All right. And how long had you, as of the January 2022 or 2023, I'm sorry, how long had you been at Richmond?
It probably would have been, between that time, it would have been like a year and a half.
Okay.
Not quite 2 years.
And during the course of your time at Rich Neck, did you come to know a student who we'll refer to as JT?
Yes.
And in the course of your duties, did you receive an assignment related to JT?
Yes. In his second year at Rich Neck, I was assigned to kind of be like his one-to-one within a set schedule.
How did that assignment come about, if you know?
I don't recall place to help them to adjust them to the school and, be more productive. So I believe the administration came with a plan up, and they administration need to help them out within that plan.
Tell us how, if you could, just describe for the jury how the one-on-one assignment worked. What did you do?
Really quiet.
In the morning, when he got off the bus or was dropped off, I would proceed to have a morning session with him, kind of set goals and plans for him in the morning. He would then go to one of the, I believe it was one of the SPED teachers to kind of reiterate those plans. After that, he was working with Mrs. Kovac on some, it was like reading assignment. She was a reading specialist at that time. And then when after her time was up, I would come back, retrieve him, and I would take him to the classroom. I would be with him in the classroom.
Okay. And did you ever speak to Dr. Ebony Parker regarding this assignment with JT?
From my recollection, I don't recall. I just remember this is when they were requesting Ebony.
Okay. Do you know of any behavior issues that JT exhibited?
Yeah, his first year there, he exhibited a variety of different behavioral issues where he was out of the classroom or taken out of the classroom for whatever case may be, but it varied from time to time.
Okay. Mr. Rawls, do you know what an SST is?
Yes.
Okay, what is that? Can you tell us?
A student support team. It was basically a process or a program to put in place to help to assist them in trying to, once again, be more productive in the school system.
And did the SST plan involve regular meetings?
Yes.
Did JT have an SST plan?
They were in the process of moving forward with SST because I believe they were trying to transition that SST into more like an IEP, which is like a more specialized support system for students, and it's called the SPED system.
Okay. And who all was involved in the SST process for JT?
I was currently at the time under Newport News Public Schools, the policies of counselors were one of the main people that ran the SST process. Administration would be involved when available and things of that nature, but it was more so put on the responsibility of the counselors.
Okay.
To coordinate the SST meetings.
And so at those SST meetings, who would typically attend JT's SST meetings?
It would be either the principal, the AP, myself, or another counselor, a parent, and if they had any advocates, anyone else that would be willing to be part of the meeting. That's how kind of group of people would be.
Were parents and guardians of children invited to attend those as well?
Yes, of course, yes.
You've mentioned principal and AP. What's AP?
Oh, assistant.
Thank you. And as of JT's SST, who was the principal at the time?
During the time, the principal...
I'm sorry, I put you on the spot.
I can't remember.
Okay, do you remember who the assistant principal was at that time?
Dr. Parker was assistant principal during the SST process in that second year, yes.
Okay. Did Dr. Parker sometimes attend the SST meetings, if you know?
I believe she may have attended some, yes.
Okay. Did there come a time when you decided you no longer wanted to, or maybe that you no longer thought it was useful to have that one-on-one assignment?
Yes, because...
Hold on just a moment.
Okay, what happened? I heard something.
I object to leading.
Object leading. Okay, response.
I'll rephrase the question.
Thank you.
Did you ever decide that you did not want to continue the one-on-one relationship with JT?
As a school counselor.
I'm going to read my objection.
Okay, same objection?
Yes, sir.
Response?
I asked, did you ever decide that you didn't want to continue the one-on-one relationship with JT? He's already established the foundation that he had the one-on-one assignment. And did you decide is a question he can answer yes or no. He did decide it or he didn't. I'm not suggesting which of those answers is the right one, so it's not leading.
Okay, I think the leading part is to just continue the relationship with JT. So I think the proper phrasing would be, did you decide whether or not to continue or discontinue a relationship with JT? So if you could ask that. Or do you want me to just...
Go ahead, Judge, if you would like to ask the question.
Did you get the question?
Yes.
Okay, can you answer? Thank you, sir.
It wasn't really a decision of sorts. It was a request. As a school counselor at that time, I had many students that I had to serve, and and I felt like it took away my opportunity to service a lot of the other students within the building. So I had requested if I could be relieved of that duty so I could also service the other students. Besides, I could still assist. However, it needed to be done with JT, but I also wanted to be able to service the other students within the building as well.
Thank you. During the time that you were working one-on-one with JT, did you experience behavior issues or witness behavior issues?
Can you repeat the question?
During the time you were working with JT, did you experience or witness behavior issues?
When we were more one-to-one, it tapered off more. He still had concerns here and there, but he knew the relationship we had, me being his one-to-one, that I would be there to help to correct or redirect a lot of his behaviors.
And what were the behaviors that you observed of JT at any point that year?
Non-compliant, defiant behavior, refusal to do work, just acting out of sorts where he wasn't following directions, things of that nature.
Would those issues ever be discussed at the SST meetings?
At times, yes.
Okay. I'd like to take you to January 6th of 2023. You remember that day?
Yes.
What is the first moment that you realize something might be up with JT?
Objection, leading as soon as facts and evidence.
I'll rephrase. On that day, did you ever notice anything unusual about JT?
On that day, I didn't even really witness him that day until later, within that evening of the afternoon of that day.
Okay. Did you eventually become aware of a crisis that occurred that day?
It was brought to my attention that after dealing with another student, that something had took place at recess where JT apparently told another student something that So I understand it's hearsay. Let me walk through that with him. During the day on that day, did you have occasion to speak with any students? Yes.
And were there any students who shared a concern related to JT?
Yes.
Now, without telling me what the student said, did you describe the student's demeanor, how they appeared at the moment they were telling you the information?
It's going for excited utterance.
Very emotional, very sad.
Okay. Again, without telling us what was said, were they referring to something they had just experienced or seen?
I wouldn't say they just experienced it, but they experienced it at an earlier time where they still holding on to whatever was taken.
Okay. And with that information, without telling me what was said, with that information, where did you go?
With that information, where I went is I went to Dr. Parker to address the allegations that I heard.
Okay. Did you ask Dr. Parker to take any action?
I didn't ask her to take any action. It was presented to me that some action was taken at a particular time with something else. And then I requested her if I could take some action.
Okay. And what action did you ask Dr. Parker to take?
I asked her if I could take action of trying to search or to check the person about JT.
And what did Dr. Parker say anything?
She responded by saying that at the time, because of the scheduling he had, his parent or parental guidance would be coming to get him so that we could hold off at that time.
Okay. The concern and the desire to search JT, did you share your concern without telling us what was said? Did you share your concern with anyone else?
The only person as I shared my concern with is when I went back to speak to Mrs. Zorn after I spoke to Dr. Parker.
Okay. Mr. Rawls, at the time that you asked Dr. Parker for permission to search the person of JT, did you believe that you had the authority to do that without an administrator's approval?
You know, in my previous experiences, you just can't, in my position, you just can't search a student without some type of permission.
Okay. And finally, Mr. Rawls, as you sit here today, do you wish you had done differently that day?
Yes.
Okay. Thank you. I don't have anything further.
Now on to cross with the school counselor who was assigned specifically to JT and did... Why are we frozen? We are definitely frozen. Hold on one second. Test 1, 2. Check 1, 2. Yep, we're good. Okay. Brief defense huddle. Defense has been most effective at limiting the scope of the umbrella that the prosecution wants to include in the actions that support the charges, specifically in things that happened after the shooting, the impact it had on the children or on other children of the school after the shooting, and the judge has been
Mr. Ross, how are you?
very quick to shut that
Good.
down.
Hopefully I won't keep it too long. So on January 6th of 2023, you were the school counselor at Rich Neck, is that correct?
That's correct.
Okay, and so at some point, was it at the very beginning of the year, did you assume the responsibility of having the one-on-one contact with JT?
Not that's at the beginning of the year, no, sir.
Okay, but at some point you began one-on-one contact with JT, is that correct?
Yes, sir.
Okay, and how were your initial interactions with JT? Were they positive, or was it a challenge?
At times it could have been a challenge, but we built a rapport from the year before where it wasn't as difficult for myself.
Okay, and so over a period of time, his behaviors began to get better. Is that correct?
I would say yes.
Okay, and you were part of the SST team. Is that correct?
Yes.
Okay, and you function as the counselor as a part of that team?
Yes, counselor coordinator.
Okay. Would you say that you were in a pretty good position to assess how JT was doing on a given day?
I would say yes.
Okay. And would you say that you had more contact or less contact with JT than Mrs. Kovac, the reading specialist?
Mm-hmm. I would say we probably had about
the same amount of time? Okay. And at some point, you indicated that you requested less one-on-one time with JT?
Yes.
But it didn't sound like it was because he was doing better, but it's because you wanted to be able to help more students at the time. Is that correct?
Yeah, from my standpoint, my point of view is to be able to get more accessible students
Okay.
Okay, if you could speak up and tap that microphone, let me see if it's on. Okay, talk into it so that the reporter can get your words down. Thank you. So, if you repeat your answer.
Oh. Can you repeat the question?
So you got to a point where you were spending less time with JT. The motivation for that was to be able to spend more time helping, I guess, more students,
yes.
More people than just JT. Is that correct?
Yes.
Okay. All right.
Go ahead, and I know we're hearing that mechanical squeaking now. We think it's a chair, so just, well, you know where it came
No,
from?
it wasn't a chair. It was a voice or something like that.
Okay, somebody tooted.
From a feedback?
It seemed to be from my right.
Oh, okay. So again, there are other courtrooms and other lockups. We can't do anything about those noises. I'm sorry. Just ignore them. These things on the wall, these are sound panels. So we have as many as we can have, as you see, to absorb all the sound. So we'll just have to do our best to move forward.
Thank you, ma'am.
Okay,
I understand.
Question, please.
So my next question is, do you when you began to have less contact with JT based on your request, did you think that was a good move for JT? Do you think that may have been detrimental to his progress?
I can't really answer that.
Okay. But based on your position, you thought as far as resources, you needed to have contact with more students. Is that correct?
Yes.
Okay. Maybe it's the. That's what it is. That's what it is. So I'm the source of distraction.
We found the tutor or the squeaker. Sorry.
So after you decided to have less time with JT, did you notice any kind of degrade or in his behavior?
Not necessarily, because another plan was put in place to kind of I won't say replace me, but to try to subside.
Describe that go around or that next plan.
For the next plan, from my understanding, was that authoritative figure within his family would be able to come in to assist him and support him in his times process and his schedule.
Okay, and so you actually observed that next phase of the plan with JT. Okay, and did that next phase seem to cause improvement with JT's behavior?
As far as I know, once I was alleviated from that, I wasn't so hands-on, but I would say it seemed like he was kind of improving, yes.
Okay, so were there less calls from a teacher or from an administrator for you to respond to JT due to bad behavior?
On my understanding, yes. There was less calls for me, yes.
Okay, all right. Now let's talk about January 6th. Did you have contact with JT on January 6th of 2023?
Later in the afternoon, yes.
Okay.
Not like direct contact. I observed him.
Okay. You said not direct contact, but you actually observed him. So as a result of hearing information, you decided to go and place your eyes on him, is that correct?
Yes.
Okay. And when you placed your eyes on him, was he in the classroom or was that on the playground? Where was he at? In the hallway?
I placed my eyes on him, he was in the classroom.
Okay. And when you placed your eyes on him, did his behavior that you observed, did it cause you concern?
No.
Okay. Did he seem like it was JT, his normal behavior? Is that
actually, it seemed abnormal behavior. He was way calmer than he normally was.
Oh, okay. So he appeared calm.
So this was
how long did you observe him?
For him?
It was a few minutes. It wasn't long.
Okay. And during that few minutes, JT was doing okay. Is that correct?
Yeah.
Okay. And is it safe to say that you may have had some concerns for JT's safety or anybody else's safety, and that's why you wanted to put your eyes on him? Is that correct?
Well, not at that time. At that time, like I said, it was abnormal for the behavior of being that calm. And
so it was
setting.
Abnormal.
Okay.
That was that calm.
I didn't have any concerns of him.
Okay. So you put eyes on him and you were satisfied that JT was doing well that day. Is that correct?
Yeah.
Do you did you have contact with him directly or indirectly after that?
No, I did not.
No contact.
Okay. So you did not observe any behavior of JT on that day that made you believe that JT presented a threat of danger or harm to any of the students. Is that correct?
That's correct.
Okay. And I believe through the questioning, it seemed like there may have been an indication that there was some additional feedback that you received. Is that correct?
Yes.
Okay. Did that cause you to need to put your eyes on JT again?
initial feedback that I received had me concerned about what was being said, and that's when I wanted to address it with Dr. Parker and things of that nature. The only other time that I saw JT, and I don't even recall really seeing him particularly, is when I went back in that classroom, and I don't remember actually seeing him at that time.
Okay. Okay. And do you remember the timing of that when you went back into the classroom?
Once again, it had to be between the hours of 12:45 to 1 something.
Okay.
But I don't recall the exact time.
At any time did you feel like that you needed to step in and pull JT out of the classroom?
Only time that I felt after hearing the feedback that I would receive, and when once again I was told to hold off on that.
Okay. Did you agree with that decision?
At the time, I felt like it was the decision that was made, and whether I agree with it or not, I was just there to be a support. When I came back to the classroom, I spoke to Ms. Zorner, I told her what was said, and I just told her that I would be there if she needed me.
Okay. When you left Ms. Warner, did you feel like you were leaving her in extreme danger, or the students in extreme danger?
No.
Okay. When you walked away from that class, you were at peace with JT's behavior, what was going on in the classroom. Is that correct?
Yeah.
Okay. Now, so when the actual incident occurred, did you immediately think that, oh no, JT has shot somebody?
No. When they went into lockdown, I thought it was a drill originally.
So you were shocked that the incident actually occurred. Is that correct?
That's correct.
Even with the earlier feedback that you received. Is that correct?
That's correct.
Okay. You did not think that you needed to take any action to prior to the incident to separate JT from the classroom. Is that correct?
That's correct.
Separate his classmates from him. Is that correct?
That's correct.
You didn't feel like you needed to call the police? Okay. All right. If you believe that there was a gun, do you understand that it was your responsibility to separate JT from the classroom?
Yeah, I mean, that would be my responsibility.
Okay.
Definitely it was.
Okay, and it would also have been your responsibility to contact authorities. Is that correct?
Correct.
Okay. You had been involved in previous incidents when JT was removed from the classroom. Isn't that correct?
Yes.
Okay. Just a couple days before that. Okay. You were involved in that incident.
Yes.
Okay. You removed him from the classroom?
Yes.
The incident wasn't something that caused danger or harm to his classmates. It's a cell phone was broken. Is that correct? And that resulted in him being taken to the office. Is that correct?
Yeah, it was like it was just disruptive a little bit, but nothing major.
Okay. So, as a staff member, even on that day, you understood it was your responsibility, if you thought that there was a threat to the students, to remove the threat or the students from that danger. Is that correct?
Objection asked and answered.
Yeah, that's fine. Ronna, can I have a moment?
Yes, ma'am.
All right, just flying through the witnesses, and we're already up to 94 objections. Thanks for no spoilers in chat. Appreciate it. Trying to catch up. This is just finishing up yesterday. We have an overworked and under-vocalized guidance counselor on the stand right now. Proper microphone etiquette was not part of his training. Could barely hear what he had to say. But it's been consistent with what the other teachers have said at the school.
Briefly, yes, Judge.
Yes, sir.
Just so that I understand the timeline of events, you testified on cross that you went and put your eyes on JT. Do you know if that was before or after you spoke with the student and it caused you to go to the assistant principal?
No, before.
It's before, okay. Do you know roughly how long before you spoke with that student?
I do not recall.
Okay. Would it have been more than 2 hours?
It was earlier that day.
Okay. And what were the initials of the student that you spoke to?
I'm going to remember the first initial is R.
Okay, thank you. I don't have any further questions, Judge.
Might have been RR. We had an RR.
From the defense for this witness.
Just a moment, Your Honor.
Hold the mic against your chin. That might be a good reference point for someone who's not familiar with it.
Hello, Mr. Ross.
They're all a little different.
You just mentioned speaking with a student with the first initial of R. Did you ever tell Dr. Parker what R has said to you?
I believe I mentioned what he had mentioned to me, yes.
You believe you did. Do you know for certain whether you did?
Certain.
Okay. Would you be surprised if you did not do that?
I wouldn't be surprised.
Okay. No further questions.
What R mentioned was R mentioned that JT had a firearm.
Judge, based on that, I'm going to need a couple of minutes.
Okay.
Before redirect, I guess.
All right. So we'll take it's a good time for stretch break and after lunch restroom break. So it's 3:25. Let's come back at 3:35. Sir, so you're still under oath, but you can step down and retire to the witness room.
Okay, we're gonna
bring you back out. And we'll have the jurors go back to the jury room.
All right, as they step out, we're gonna skip ahead just a little bit as we're catching up. They get a little bit of a break. Well, this witness just testified that he, in fact, did not tell the assistant principal that RR said there was a gun, or that JT had a gun. Break's over now. We're on catch up. Stop stretching. We're done. Break's over. Stop stretching.
All right, sir. If you resume the witnessing and the sheriff, we can bring the jurors back out.
Yes, ma'am.
Yes, News, you need to come and connect audio. Please come on up. Okay. Thank you.
I got this one.
You got that one. What about the other one? He said this one. Okay.
Yeah, I turned both of them.
Okay, thank you.
Yep, that's all you have time for. You got to stretch fast. Leave stretch marks. I'll tell you, be careful though.
Please rise for the jury.
Just realized I have the title wrong. You guys told me it was wrong, and I hadn't fixed it.
Jurors in the warrants.
Okay, you all may have a seat. Thank you. You may resume your redirect. I'm sure
This is redirect.
Okay.
Yes, be quick.
Redirect.
Mr. Rawls, thank you. I believe you indicated to the defense counsel that you didn't remember what you had told or whether you told Dr. Parker about the incident at the time you asked for permission to search the backpack. Is it true that you don't remember that? Sure. Understandable. Did you give a statement to police in this case?
Yes.
And if I were able to provide you with a transcript of that, might it refresh your memory about what you said to Dr. Parker? Okay. May I approach, Judge?
Okay, yes. And you responded yes, correct?
Yes.
Okay. And he nodded his head. I just wanted to make sure it was recorded. Yes, you may approach.
Thank you. I'm just handing you this document. I want you to take a look and read there where I put a pink post-it note. And after you're done reading, look up and I'll ask you a question.
That's it.
Hold on, don't read it. Yeah, sorry. Read it to your. Just read it silently, and then I'll ask you a question about it. Sorry. And does that refresh your memory about what you said to Dr. Parker regarding the incident?
To an extent, yes.
Okay. Would you just tell us then what it was you said to her?
I'm looking at the witness. He this point, he looks like he's looking at the page, and he's going to be looking at the page and then advising. So his memory has been refreshed.
I'll take it back.
Okay.
I'll go get it.
So what's your,
May I approach?
okay, you just like him to.
I want this done properly. Yes, Your Honor.
Yes, may I approach?
You may approach.
Thank you.
And ultimately, for parties, the legal principle is you can't read from that statement. You can refresh your memory, but you need to testify from your memory. Okay.
Based on now let's refresh if he has an independent recollection.
Well, he said to an extent, so we'll flush it out, and we'll give you the opportunity to cross. Go proceed, Mr. Jenkins.
Having refreshed your recollection, do you remember what you said to Dr. Parker prior to asking to search the backpack?
Yes, when I spoke to Dr. Parker, it was already relayed to me that a book bag was searched from JT, and that nothing was found within the book bag.
Do you remember if you confirmed with Dr. Parker that you and she knew what you were talking about? Or who?
I know enough that we confirmed that we thought something may have been in the backpack, yes.
Okay, thank you. I don't have anything further.
And Mr. Rawls, and from what you just recounted, nothing was in the backpack, correct? It had been searched and nothing was there, correct? Okay. And at that point, you did not believe there was any credible threat, correct?
Objection asked and answered on recross.
The first recross.
I'll withdraw the question, Your Honor.
All right, thank you. All right, anything further for this witness?
No, Your Honor.
Please.
All right, and the status for Mr. Rawls. May he be excused of this, he needs to remain.
He needs to remain.
I'd ask, oh, I'm sorry.
No, I'll follow you.
I'd ask that he be released.
Oh, no, we're going to ask that he be released.
So we're going to ask that he be constructed. I agree to that. We'll ask that he be constructively sequestered, remain available for recall.
Are you, is that suitable to the defense?
Yes, sure.
Okay, and do you all have his phone number?
No, Commonwealth hasn't.
Absolutely, I do be happy to facilitate that happening.
Okay, so Mr. Rawls, what that means is you are still a witness. You still have the ability to be recalled. So do not discuss this case, do not discuss your testimony, but you do not have to stay in the courthouse, you do not have to stay in the witness room. You can leave or go about your daily business. You will either get a phone call, 1, to come back to the courtroom, or 2, that the trial is over and that you are no longer a sequestered witness. All right, any questions, sir? All right, thank you. You may step down. Next witness.
Megan DeLeon.
Megan DeLeon, is what I heard. The door on the right goes to the witness room. The door on the left goes to the jury room, I guess. I don't know. Maybe that's the door on the left goes to the lockup. Choose your door wisely. They have 3 witness rooms. They've had to put multiple witnesses in each room. Defense has already been expressed concern that they're talking to each other about the case. They have no evidence to support that, but they're like, it's reasonable that they would. If you missed it yesterday, there was a point where, or yesterday as we were watching, there was a point where both sides requested to have a mistrial.
Raise your right hand. Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Thank you, ma'am. Please walk around, please, to the witness stand, watch your step. The chair and microphone are adjustable. All right, you may proceed.
Good afternoon. Would you please tell us your name?
Megan DeLeon.
Ms. DeLeon, do you have a daughter?
I do.
I want to just caution you, and I know we've discussed this, but during the course of this trial, we're not using any children's names, only using initials or referring to your daughter if you prefer. Back in January of 2023, was your daughter attending school?
Yes.
Where?
Rich Neck Elementary.
Is that here in Newport News?
Yes.
And what are your daughter's initials?
SD.
On January 6th of 2023, did you become aware of an incident that caused you to go to the school early?
Yes.
And when you got to the school, did you immediately see SD, your daughter? Do you eventually see her that day?
Yes, when they bring her out to me.
Okay. When you first see her, describe, without telling me anything she said, just describe her demeanor, how she appeared to you and how she interacted with you.
Initially, she just seemed happy to see me, her dad. It was later on in the evening when she kind of showed different behavior.
By different behaviors, you mean different than prior to the events of January 3rd? Describe what behaviors you observed.
Just that evening, it was a very hectic day, so we just ordered a pizza in and just tried to put some show on to kind of... But the doorbell rang just for the pizza, and she just got very scared, jumped from her seats. The sound of a doorbell and other sounds like that for many months to come just scared her.
What kinds of sounds would scare her?
Slamming of the door, I know, just loud bangs. She described the sound as a ladder falling when the gun went off. And so loud sounds have startled her.
Mayor, I'm going to object to her statement. Sounded like a ladder when the gun went off.
Defense objects.
Sounds like she's testifying as statements that SC may have stated.
Based on hearsay.
That's what she has done. I'm objecting to this.
Objects to the sounds that sound like a ladder falling when the gun went off.
If the request is to strike sounds like a ladder when the gun went off, I agree to that.
Okay, so struck, don't consider that, please. Next question.
So what other behavioral changes, if any, related to SD did you notice in the immediate days and weeks?
Not understanding why this happened. She loved her teacher. The teacher was kind, and she just understand why anyone wanted her.
And who was her teacher, if you know?
Miss Warner.
Okay. So Miss Warner, was Miss Warner's classroom her homeroom?
Yes.
Okay. As a result of what you observed with SD, did you seek help for her of some kind?
Yes. We went to just regular counseling through our insurance, and then also spiritual counseling through my church.
And how long did that go on for?
6 months.
That's strong objection relevance.
Response.
These are the injuries that the neglect caused, the trauma to the children, and I believe that that is relevant.
So I'll allow it, but do you have additional questions down this line, or do you have additional questions in this line of questioning?
Only to elicit any additional different things that she noticed in her daughter. That's it.
I'll allow it. You may proceed.
Okay. We're from January 3rd to present. Any additional things you've noticed in your daughter that were not present prior to the January 3rd incident?
She's very, she doesn't want to talk about it. She keeps everything in close hold. She holds in a lot of feelings and emotions. Recently, she went back to counseling because it's the time they said to start doing it, to give her some time and re-engage with the counselor, and they said that she has depression, anxiety, and one other thing where she's always on alert.
All right. Thank you. I don't have any more questions for you, but thank you.
Hyper alert.
Good afternoon, Ms. DeLeon. You were never inside of Rich Neck Elementary School on January 6, 2023, correct?
In the building? No.
Okay. And you did not encounter your daughter in the building, correct?
Right out front. No, they brought out to me.
Okay. You filed a civil lawsuit arising from the events of January 6, 2023, correct?
Yes.
In this courthouse, correct?
In this courthouse, well, through Newport News, yes.
Okay.
What do you mean by that?
That's a pending lawsuit in Newport News Circuit Court, correct?
Yes.
Okay. And you've named Dr. Parker as a defendant in that case?
Well, I prefer not to talk about my opinions of the case.
You don't get a choice.
Well,
it's more of a
I'm going to object, Judge, and ask that we not talk about a child's civil matter on TV, that we have not continue the broadcast.
It's
while
a civil
she's speaking
suit.
about the civil suit that is her child's, really, not hers.
But she filed it.
The court's ruling will be the same as earlier, so the objection will be overruled. She's been cautioned that we're only using initials, but the questioning party has a right to cross-examine about interest in the case. And if you just ask who the named party is, not what your opinion is. But I think you said I prefer not to share my opinion on it. So non-responsive as well. Repeat your question, Mr. T.
Thank you, Your Honor. In that civil lawsuit, you have named Dr. Parker as a defendant, correct?
Yes, I believe so.
Okay. And you are seeking money damages from the defendants in that case, correct?
I'm more seeking justice for my daughter and what she went through.
And you are seeking money damages from the defendants in that case, correct?
Yes, there is settlement and discussion with that, yes.
Yes, but the I know there are settlement discussions, I'm sure there are. But in terms of what you're asking for in that lawsuit is money, correct?
That's what civil suits do.
Okay. And you believe that a criminal conviction of Dr. Parker would help in that case, correct?
I don't have any opinion about that or anything to say about that.
Okay. After January 6th, you requested that your daughter be transferred to a different school, correct?
Yes,
And that request was refused by Newport News Public Schools, correct?
it was.
Okay. No further questions.
Thank you. Anything further from the Commonwealth?
No, Your Honor.
All right. And the status of this witness?
We'll ask that she be released, and we're also calling Nicholas De Leon.
Any objection from defense to this witness being released?
No, Your Honor.
Thank you, ma'am, for your testimony. You are released as a witness. You are welcome to remain in the courtroom, or you may leave the building. Thank you. And the next witness's name again, I'm sorry.
Nicholas De Leon.
Okay, Mr. De Leon, please.
This would be, I believe, the husband.
I'm going to object to the testimony of the next witness because I believe it's cumulative. I don't think that we will be able to testify to anything other than...
Ding, 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 ding. We just hit 100.
I don't know who they are. So, okay, tell me why it's cumulative.
Husband what?
Mother and father of the child.
Okay, it's just one witness. I'll allow. I mean, are you bringing out 5 relatives for the same child?
Absolutely not, Your Honor.
Okay,
Absolutely
you can
not.
come out
This is
overruled. Mr. De Leon, please.
Paging Mr. De Leon. Paging Mr. De Leon. Please come to the courtroom.
Do you swear affirm the testimony you're about to give is the truth, whole
Is that a
truth, and
tweed
nothing but the
jacket?
truth?
Yes.
Sir, please take the witness stand, watch your step. Chair and microphone are adjustable. You may proceed.
Good afternoon, sir. Would you please tell us your name?
Nicholas De Leon.
Mr. De Leon, just a reminder that we're not using the names of any children at all, including your own. But do you have a daughter?
I do.
And what are her initials?
SD.
And where did SD attend school?
Richmond Elementary.
Okay. And as of January 3rd, 2023, were you, let me ask the question like this. Who is SD's mom?
Megan De Leon.
Thank you. Between the time of January 6, 2023, before and after, were there any changes that you noticed in your daughter SD after that hadn't been there before?
Yes.
Could you just describe what you personally noticed or observed, but not anything that she said to you?
I noticed that she was anxious, depressed, very not like herself, as in being quiet, distant, couldn't sleep.
How long did that persist?
Quite some time.
Okay.
Months.
Okay. Did you and her mom seek any sort of treatment for her?
Yes, counseling and spiritual counseling.
Has it helped?
I think it's hard to say at this point. She's still going through counseling. It's been up and down, I think, with her.
All right. And just to confirm, whose class was SD in?
Ms. Waters.
And was that at Rich Neck Elementary?
It was.
All right. Thank you. I don't have any other questions for you. Please answer any from defense counsel.
Good afternoon, Mr. De Leon. All right. You mentioned your daughter SD. You don't have any knowledge of whether SD was in the classroom when Ms. Werner was shot, do you?
I was not there in person, but that is her classroom.
I understand. But you don't have any idea whether she was actually in the classroom, correct?
From what I understand, that she was in the classroom.
And what are you basing your understanding? Is that from somebody told you?
Again, I was not there.
Okay.
I can't verify that. But
So you can't verify that. I'm not asking you to tell me what you were told. That's hearsay. Okay. Now, you are aware that your wife, or I don't know the status of your relationship, but Megan De Leon has filed a lawsuit on behalf of your daughter in this courtroom, correct? I mean, this courthouse, correct?
Yes.
Okay. And that you're aware that Dr. Parker is a named defendant in that lawsuit, correct?
That's correct.
Okay. And you're aware that money damages from Dr. Parker are being sought in that lawsuit, correct?
Correct.
Okay. And so you have a financial interest in a criminal conviction of Dr. Parker, correct?
I don't. It's on behalf of my daughter.
Oh, so you believe your daughter has a financial interest in the conviction of Dr. Parker?
Today? That's a separate case.
Just answer my question.
That's a separate suit.
Answer my question. Do you believe that your daughter has a financial interest in the criminal conviction of Dr. Parker?
Today, I don't believe so, no.
Do you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit?
Objection asked and answered. He said no.
No, it has not been asked and answered. Your Honor, I asked a different question.
Well, it's a different question, and I think you already answered it. Are you asking this answer to be struck?
Yes. It's irrelevant and duplicate.
Overruled, and your answer was no, sir. If I heard you correctly?
Correct.
Okay, thank you.
No further.
Questions?
No further questions, Your Honor.
Any redirect?
No, Your Honor.
And status of this witness?
I would ask that he be released.
Any objection?
No objection.
Okay, thank you, sir. You're excused from your duties as a witness. You may stay in the courtroom or leave, as you see fit. Next witness.
Stay or leave.
Commonwealth will call Tanisha Richardson.
they going to call every parent from every child in the class and the adjoining class? There are 20 parents in the class. There are 20 students in the class. We're just finishing up the end of yesterday right now. I think we'll be...
Raise your right hand. Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Yes.
We've got less than an hour left on yesterday's.
And watch your step and take care of microphone or distance.
Good afternoon. Would you please tell us your name?
Good afternoon. My name is Tanisa Richardson.
Ms. Richardson, do you have a child?
I do.
And in January of 2023, was your child in school?
Yes.
What are your child's initials?
KS.
All right, and just as a reminder, we're only using initials, not names today. Where was your KS in school?
He was in his classroom. He was in first grade in his swingers class at Richmond Elementary.
All right. And did there come a time earlier than normal on January 6, 2023, when you had to go to the school, Rich Neck, to pick up KS?
Yes. I received notice that there was a community post on social media that there was a heavy police presence at the school.
Okay, let me stop you there. Let me. You're okay. Just let me ask you questions, and I'll walk you through it. Okay. So after you saw what you saw online, did you go to the school?
I did.
Were you eventually reunited with KS?
Yes.
Could you describe, without telling us anything that he said, could you describe his demeanor, how he appeared to you when you first saw him?
He was very tired. He was cold. And he was ready to get home. He was just really exhausted from the day.
Yeah. Did you notice any changes in his behavior after January 6th of 2023 as opposed to before?
Yes.
I want you to just describe what you were able to notice as his parent that changed after January 6th, 2023.
Ayden experience. Oh, sorry.
Oops.
It's okay. I understand.
And the news is directed to They'll tweet that, so it's not going to go out to the press. I just wanted to assure you, we will catch it.
It's live. It's live.
Just extreme fear as well as hypervigilance.
When you say school avoidance, can you kind of describe to me what that means?
He was literally afraid to return to school.
How long was he afraid to go to school?
I would say until at least the end of the school year of that year.
The judge just told you all to forget it.
Did you seek any type of treatment for KS?
I did.
Okay. What did you seek?
He actually had a psychologist initially, and then he also attended CBT therapy with a counselor weekly.
And how long did that go on, and is it still going on?
I would say it lasted about 1.5 to 2 years, and we stopped it since then because his therapist went to a new practice.
Okay. Do you think that it has helped KS?
It has helped.
Good. All right. Thank you. I don't have anything further for you. Thanks.
Good afternoon, Ms. Richardson.
Good afternoon.
You currently have a civil lawsuit pending in this courthouse, correct? Regarding the incidents of January 6, 2023?
Yes.
Okay. And you've also, in that lawsuit, you've named Dr. Parker as a defendant, correct?
Unfortunately, I'm not. I don't feel comfortable discussing the details of that in this arena.
They've all been prepped to say that.
Renew my prior objection. I understand the court's rule on the issue.
So the court will overrule the objection. It's appropriate to be discussed. So if you could please answer the question. Repeat your question, Mr. Teague.
Thank you, Your Honor. In the lawsuit that you currently have filed in Newport News Circuit Court, you have named Dr. Ebony Parker as a defendant, correct?
Correct.
And in that lawsuit, you are suing Dr. Parker and the other defendants for money, correct?
Yes.
Okay. And you and several other parents share the same attorney, correct?
That's correct.
And you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit, don't you?
No.
Okay.
How can that answer be no, honestly? Because if you're convicted for it, you think you're going to bring that up as evidence in the civil suit? This person was convicted for doing this. We have damages.
Have you made any other demands of Dr. Parker or the other defendants?
No.
Okay. Do you know when that lawsuit is scheduled to go to trial?
No.
Okay. When was that lawsuit filed?
I believe it was February of 2023.
February 2023?
I don't know.
Okay. Okay. No further questions, Your Honor.
You may proceed.
Just a couple of more questions for you. As a result of the incident on January 6, 2023, and all of the things that your son has done, have you spent money?
Yes. I'm going to object to go beyond cross-examination.
I think that's right on point with the cross-examination. He asked if she was seeking money in a lawsuit, and I think it's very fair for me to ask if she also spent money as a result of the incident.
I'll allow it. You may proceed.
Did you spend money as a result of what happened to your son?
Yes.
All right, thank you. I don't have anything further.
Anything further for this witness?
No, Your Honor. I ask that she be released.
Any objection to her being released?
No, Your Honor.
Thank you, ma'am. You are excused as a witness. You may stay in the courtroom or leave the building. Next witness.
The next witness will be Ramon Gonzalez. Your Honor, I anticipate having this witness plus one more.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
I do.
Please take the witness stand. Watch your step. Answer questions for counsel. Thank you.
Good afternoon, sir. Would you please tell us your name?
My name is Ramon Sebastian Gonzalez Hernandez.
Thank you. And I would like to just a quick reminder that during this trial we're not speaking the names of any children at all and only using initials. Do you have a child?
Yes, sir.
What are your child's initials?
GG.
And did your child attend school, did GG attend school in January of 2023?
Yes, he did.
What grade was he in?
First grade.
And where did he attend school?
At Rich Neck Elementary.
Do you know who his homeroom main teacher was?
Yes, I do.
Who was it?
Abigail Zorner.
All right. Did there come a time on January 6, 2023, when you had to unexpectedly go to Gigi's school, Rich Neck?
Yes, I did.
And when you arrived at the school, did you immediately see Gigi?
No, I did not.
Okay, stay with me and let me walk you through it. Okay. So eventually, did you see Gigi at the school?
Eventually, yes.
And when you saw him, could you please just describe, without saying anything that he said, describe his demeanor, how he was acting, and how he appeared to you?
He walked out of the school with a look on his face like he had seen a ghost, pretty much. I was crying myself. He wasn't crying, but he was in shock, a complete, utter shock.
Okay. And from that moment forward, did you notice any changes in behavior from Gigi as opposed to before January 6th?
Yes, at home he was a little bit snappier with his brother. Whenever they would argue, he would be a little bit more aggressive. Other things like he had to sleep with him every night because he just felt more comfortable. Bedwetting almost every night. Things like that.
And were all of those things new after January 6th?
Yeah, that was new after that. Okay. He loved to sleep by himself before that.
And did your family seek some help and treatment for Gigi?
Yes, we did. Right after the incident, we went, I want to say 2 or 3 times. Mm-hmm. And he was very adamant that he didn't want to go because we wanted to keep his life as normal as possible after the incident. So wasn't trying to force it down his throat.
Okay. And has he, at any time between then and now, has he sought any treatment beyond that?
Not since then, no.
Okay. And how long did any concerning behaviors that you've described last?
It still lasts to this day. Getting better gradually, I think. But still, he has a lot of mood swings, and the whole big wedding thing that happens. Yeah, it's very rough.
Did your family incur any expenses as a result of this?
As far as with the
for Gigi, as a result of this, did you have some expenses?
No. With the therapy that was provided, so we didn't have any expenses as far as that.
Okay, thank you. I don't have anything else for you.
Okay, thank you.
Good afternoon, Mr. Gonzalez.
Good afternoon.
You weren't at Rich Neck Elementary School on January 6, 2023, correct?
I picked up my GG that day.
But you were not inside of the building, correct?
No.
You learned about the shooting after the fact, of course. Did the school contact you at the time of the shooting?
No. I had a friend of mine, a coworker, contact me and told me about the shooting.
But did the school ever contact you?
Afterwards, yeah.
How long after?
I would say an hour and a half.
Okay. Your child was not in the classroom where the shooting occurred, correct?
Yes, he was.
Okay. And you're saying he was a student in that classroom?
He was a student in Ms. Werner's classroom.
Okay. And you filed a civil lawsuit in this case, stemming from the events of January 6, 2023?
I don't feel comfortable talking about that.
And Your Honor, I'd like to note my continuing objection.
Okay, so noted. Sir, you do need to answer the question, please.
Yes.
Okay. And you have named Dr. Parker as a defendant, correct?
Yes.
All right. You're seeking money damages from Dr. Parker in that case, correct?
Yes.
Okay. And a criminal conviction of Dr. Parker would be helpful to that lawsuit, wouldn't it?
I'm not sure about that.
Okay. No further questions, Your Honor.
No, Your Honor, I ask that he be released, please.
Any objection from defense?
No objection, Your Honor.
Thank you, sir, for your testimony. You may step down, and by release, you can leave the courtroom or stay in the courtroom, but you're no longer needed as a witness. Thank you.
And the Commonwealth will call Sarah Gonzalez.
Your Honor, again, we're going to object. This is a duplicative witness. That adds nothing to the case. This is the last other parent of the child.
Last witness
So noted, overruled.
for the state.
Thank you. And this is the last witness?
This is the last witness, Your Honor.
I'm not going to, I'm just trying to line up.
I understand. I understand. I will take a moment to double check that this is the,
Understood.
that we're
Understood.
into, but yes.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Thank you, ma'am. Please take the witness stand and watch your step. Chair and microphone are adjustable. You may proceed.
Good afternoon. Would you please tell us your name?
Ouch.
Hi, Sarah Gonzalez.
Ms. Gonzalez, do you have a child?
Yes.
Remember that we're only using initials or referring to your child as my child. What are the initials of your child?
G.
And who is Gigi's father?
Ramon Gonzalez.
Okay. I want to take you to January 6 of 2023. On that afternoon, where were you when you first see Gigi?
After the incident, when I saw him.
When you first see him on January 6, 2023.
At our home.
Okay. When you first see him at your home, is it still on January 6?
Yes.
And do you know roughly what time it would be?
It was in the evening.
Okay. Could you just describe for me, without telling me anything he said, but could you describe his demeanor, how he appeared, and how he was acting toward you?
When my husband came home with him in the car and he came out, he was like he had seen a ghost, kind of. He was white, and his eyes were very big, and he was just kind of, I've never seen that look before, but he was kind of like he was in shock.
Okay. Were ongoing after that day, were there any issues with Gigi that you noticed that were different than prior to the January 6th?
Yes.
Describe those to us.
He couldn't sleep by himself anymore. He had to sleep with someone else, and it just is, to this day he still sleeps with his older brother, and he just refuses to sleep by himself. And he frequent bedwetting started occurring after that, and frequent bouts of losing his temper, and just becoming angry, things like that.
Yeah. And for how long did those things last?
For a long time. It's improved, I would say, but it still occurs. It was very frequent after that for quite some time.
Are there any other major life adjustments that your family had to make as a result of what Gigi went through?
trying to internalize it and, move forward. And, it's the impact on my husband and myself. It was pretty significant and caused a lot of anxiety and,
Objecting relevance to the impact on the ball.
Objection was
I
relevance.
agree, Judge. We won't go down that road.
Okay, so we won't consider that just to the child. Next question.
I don't have any more questions. Thank you so much. Please answer any questions from defense counsel.
Let's find out about this lawsuit.
Good afternoon, Ms. Gonzalez. You have filed a civil lawsuit in this courthouse as well regarding the events of January 6, 2023, correct?
I don't feel comfortable speaking on that as it's relevant to my son.
Okay, objection noted. Can you give me the answer, please? Repeat the questions.
You have filed a civil lawsuit related to the events of January 6, 2023 in this circuit court, correct? And you have named Dr. Parker as a defendant in that matter, correct? And you're seeking money damages from Dr. Parker and the other defendants, correct?
Am I still liable to speak on this?
Yes, ma'am. You need to answer the question, please.
Yes.
Okay. In fact, you and several other parents are represented by the same attorney, right?
Objection, Judge. That is not who they are represented by in the civil suit. Is not in any way relevant.
Response.
I think it's relevant. We have a series of witnesses, all filing civil lawsuits, and represented by the same attorney. I think it's totally relevant to these proceedings.
And I object to counsel saying they're all represented by the same attorney. He's not testifying.
Correct. That's not evidence.
Well,
and I'm going to sustain the objection. Who their attorneys are is not relevant. But, that there's a lawsuit is relevant for cross-examination. Next question.
And a criminal conviction of Dr. Parker would help in that lawsuit, right?
Imagine, yes.
What was your answer? I'm sorry?
Yes.
Okay. So you have a financial interest in these proceedings, right?
Yes.
I'm sorry?
I imagine that's part of it, yes.
Okay. No further questions.
That's all for this witness, Judge, and I would ask that she be released.
Any objection? Okay, ma'am. So you are excused from being the witness. Thank you for your testimony. That means you can stay in the courtroom or you may leave. And watch your step as you step in.
Judge, may I have just less than 1 minute?
Yes, sir.
To confirm.
You can step down. Thank you, ma'am. And
Ma'am, you're done. I appreciate that Ms. Gonzalez there answering truthfully. Yes, she was prepped to say she didn't want to talk about it, but judge said otherwise, and she had to talk about it. Now, that's how the state's going to rest their case, with the last witness admitting that they have a financial
Your Honor,
interest in
the
this.
Commonwealth rests.
Commonwealth rests.
Your Honor, we will have motions to strike, but I do want to take time with my co-counsel and the defendant to make sure that we have every base fully covered. So I'm going to ask the court to consider going on recess for the remainder of the day, and then we'll come back first thing tomorrow and make our motions and present any evidence on behalf of the defense.
He says, let's break for the day.
Proceeding in that chronological fashion, your position.
I'll submit to the court.
Okay. All right, so to the jury, we take up the motion to strike outside the presence of the jury. It's 4:25 today, and they're asking to do so in the morning. So I will kindly ask you all to report back and would you like the jurors to report? What time is the council prepared to do motions to strike in the morning? 8:30 or 9? And I'll give that an hour and ask the jurors to report an hour after that.
Any time is fine for you.
Understood.
Your Honor, we can be prepared for 9 o'clock tomorrow morning.
Say that start at 9?
Yes, 4 motions to strike. Yes.
4 motions, and ask the jurors to report at 10.
Yes, ma'am.
Okay. All right. So thank you again for day 3. You have the same cautionary instruction. Please do not discuss the case, research the case, allow others to discuss it and/or share their discussions, their thoughts, and opinions with you. I know that's hard. I know this is a high-profile case, but that's important to the integrity of the process. And please report at 10 a.m. Are there any issues or anything I can assist you all with? Okay, and last, please, I will not be able to court to provide lunch tomorrow. My assistant's off. And she's the one who, while we're here, actually goes to
Bring your own lunch
so bring your
tomorrow.
lunch or be prepared to go out to get food tomorrow. All right? Thank you very much.
Okay.
Please rise for the jury. Make sure you move your elbows.
That completes everything for the end of yesterday. That brings us to today's events. We're going to bring that up just in a minute. Know that we're not up to the minute live, but we're very close. Thanks for no spoilers. Anyone who does offer a spoiler gets to think about it for a day. That's 86,000 seconds of timeout. So thank you for not even insinuating anything.
Thank you, Sheriff. Anything else from the Commonwealth of Defense to take up before we make our evening recess?
No, Your Honor.
Nope. Okay, we're done. All right, in that case, we can now go to today. Dum, bum, bum. Okay, let's see if we can bring that one to you right here. I think we've got just a minute before court starts. I'm going to see if we can fast forward. Hold on just one second. Hold, please. We're getting there. All right, give me a second. We're gonna skippity doo dah ahead just a tiny bit till the judge comes in. I'll be just taking our sweet time arriving. There we go.
Please rise.
All right, on to this morning. Morning, Super Team.
Honorable Judge Robinson of Circuit Court, now presiding. Ladies and gentlemen, as always, there'll be no talking while her honor is on the bench. You may be seated.
Good morning, everyone. Are we ready to call the case of Commonwealth versus Parker?
We are.
And to the media personnel, the buttons that we have to press to turn on the audio are all in place? Okay, thank you. All right.
Buttons have been pushed, ma'am.
Commonwealth versus Parker.
Except for your mic.
Let it reflect the Commonwealth attorney is present, Mr. Jenkins.
Boost this audio.
Good morning to you both.
Good morning.
The defense is present, Mr. Rogers and Mr. T. Good morning to you both.
Good morning.
The defendant is present, Ms. Parker. Good morning to you both. We rested yesterday. Is there anything you need to address this morning?
Yes, Your Honor. I have two matters.
Okay, yes, sir.
The first is that the court yesterday, as I understood it, we agreed to admit the full and unredacted interview between Dr. Parrish and Dr. Parker. I needed time to just place that on a USB drive. I have done that. It's on Madam Clerk's counter there. I understood at the time that the court had admitted it, and I just needed to provide it. But if the court had not admitted it at that time, I am moving to reopen and admit it as Commonwealth 6.
Any objections?
Not any objections to reopening for the purpose of amending that.
That's it.
Okay, so the Commonwealth is reopened, and we will admit it. Does Madam Clerk have it now?
Yes, it's
okay.
right there.
All right, and this would be 6, Madam Clerk?
Yes, ma'am.
Okay, so admitted, and again, this is just the full video of what's already a redacted version in evidence. Okay, and now that that's done, do you rest again, Mr. Jenkins?
Yes, we rest the reopened case, yes.
Okay, and the second matter?
Second matter, Judge, is just as a preliminary matter, I understand that the defense, pursuant to their own subpoenas, intends to call as their witness several witnesses that have already testified, including Ms. Werner, Ms. Kovac, Ms. Parrish, Ms. West, perhaps others. And I just want, as a preliminary matter, to point out Jones v. Commonwealth 2023 VA Act, Lexus 294, decided May 16th of 2023, which holds that it is not proper for the defense to do any impeachment when it calls its own witnesses. And so I am asking the court to instruct the defense not to do any impeachment and not to recross on matters that they already had a full opportunity to cross on. But I certainly would not object to them eliciting new evidence in their client's favor from those witnesses. But in terms of recrossing the witnesses they've already crossed, that would not be proper. They're here pursuant to the defense subpoena.
You don't call a witness to impeach them.
Yes, sir. Thank you. Response?
Yes, Your Honor. We would be asking, in the event of calling these witnesses, that they be that we be able to examine them as hostile witnesses.
Okay. And so ultimately, we will cross that bridge when we get to it. You all are entitled to call whatever witnesses you wish, and if they meet the qualifications to be declared hostile or adverse and be treated accordingly by impeaching and or leaving questions, then if they meet that statutory criteria, then that will be allowed. So Mr. Jenkins, I understand your objection now, and it'll be ongoing, and when we get there, we will address it. But again, if they meet the criteria for being a hostile witness, the court will allow them to be treated as such.
And then it's an impeachment.
All right, thank you. Okay, so with the Commonwealth resting, defense asked to prepare time to prepare their motions to strike, and we'll start with them this morning. Are we ready for that?
Yes, Your Honor.
Okay, I'm ready. Please proceed.
Your Honor, the Commonwealth has filed 8 indictments for felony abuse and neglect of children. I'm going to just sort of assume that the Commonwealth is proceeding under the fact that there were at least 8 children that were abused and neglected on January 6th. Your Honor, if that's the case, I would say the Commonwealth hasn't established that there were 8 children present in the classroom on that day when this incident occurred. The Commonwealth definitely hasn't established 8 separate incidents. So we have one incident where I guess potentially the Commonwealth believes that there was 8 children present. But the Commonwealth did not present the names of 8 individual children that were in class that day. They presented no roster or role that was confirmed by any employee that was on staff that day. And more importantly, the Commonwealth is required, I'll just read the jury instruction. In this charge of the crime of child abuse and neglect, the Commonwealth must prove beyond reasonable doubt due to the following elements of evidence. And I know that at this point where it's likely suitable to the defendant was a parent, guardian, or other person responsible for the care of whoever these children are, these unnamed children, and that these unnamed children, this unnamed child or children are or were under the age of 18. There was no testimony that any individual child that was present in the classroom by name was under the age of 18.
But there was testimony there were 20 kids there that were about 6 years old.
Has to prove the defendant's willful act or omission in care of whoever these unnamed children are was so gross, wanton, and culpable to show a reckless disregard for human life. There is instruction that discusses the definition of willful says, a willful act is one done with a bad purpose or without justifiable excuse or without ground for believing it is lawful. A willful act is intentional or knowing or voluntarily as distinguished from accidental. The terms bad purpose or without justifiable excuse require knowledge that a particular conduct would likely result in injury or illegality. Your Honor, in my own words, the Commonwealth has to establish that Dr. Parker knew, and her response was, so what? I know that there's a weapon and that there's a likelihood that children will be harmed by that weapon or firearm, and I don't care. Let whatever happen is going to happen. There was no evidence that was Dr. Parker's response to anything that happened on that day. She was brought limited information, and she responded to the information that she had. Again, I asserted at the very beginning of this, if we look at the behavior of everyone that had contact with JT on that day, they did not believe that there was a firearm. They did not believe that there was a weapon. There was testimony from Thomas Warner. She was the person that had the most direct contact than anyone on that day. Her behavior did not indicate that she believed that there was a weapon. She left JT in the classroom. She left other children in the classroom. Then we go to Ms. Kovac. Again, she sat with him, had her eyes on him, watched his behavior. She said it was weird, but her actions in no way indicated that she believed that there was a firearm in possession of JT. And then we consider what Mrs. West testified. She said there were some concerns. She actually observed JT on the playground with the other children. Based on her observations, she was satisfied that there was no weapon. And she only became concerned again when there was a report almost contemporaneously with the shooting that there in fact was a weapon. And then we consider the testimony of Mr. Rawls. He had a lot of contact with JT leading up to this event. On the day of the event, concerns were brought to him. He investigated, put his eyes on JT, was satisfied that JT did not present a danger of harm to the students in the classroom. Your Honor, based on the information that Dr. Parker had, she made decisions. In hindsight, those decisions actually were determined not to be the correct decisions. But that wasn't her decision wasn't an act of neglect. There was no bad purpose, obviously. She didn't intend any harm to the students. Without justifiable excuse, Your Honor, based on the information she had, she took actions that she believed were appropriate based on the circumstances. And so there was no bad purpose. There's really no excuse that we're trying to say other than she did not believe that there was a weapon, so that explains her conduct on that day. So there was no information that she had that she came to the conclusion that was going to lead to harm of her students. And then after coming to that conclusion, she decided that she didn't care, so what, I'm going to leave that threat of harm to those students because of JT having a firearm. The Commonwealth hasn't met its burden to establish a willful act. The Commonwealth has not established the specific names of children and their ages that were present in that classroom, being asked to consider striking the Commonwealth's case.
Okay, so defense asked to strike the case, all 8 charges. So they haven't met their burden. This is a judgment of acquittal, they call it a motion to strike in Virginia. Defense gets, or state gets to respond now.
Your Honor, I'll try to address defense counsel's arguments in order. The first was that he did not specify children having been in the classroom, or prove that children were in the classroom. What the Commonwealth is required to prove is actually what is in the indictment. And what's in the indictment is being a person responsible for the care of students under the age of 18 at Rich Neck Elementary School. So there's no need for us to prove that they were in the classroom necessarily, though certainly victims, we would argue, are in the classroom, but only at the school. That we did not present specific names is not required. The requirement of the statute is that a person responsible for the care of a child under 18 willful act of omission was so gross, wanton, and culpable as to disregard human life. The statute defining what must be included in an indictment does not include a victim's name. And we can think of common examples of indictments that sometimes don't. For instance, did assault and batter another is a very common indictment that does not include any victim's name. So the jury would, the way it is indicted now, be free to find up to the number of victims that they believe existed, in this case with a maximum of 8. And certainly no indictment can be returned twice for the same victim, and that can be explained to them. But at the end of the day, the jury is the fact finder, and they can decide whether what number of victims there were, if any. And so we think it is inappropriate to try to narrow that to specific names, but rather that the jury can decide based upon the evidence that they have how many to return or to return none. I'm sorry, how many to find guilty on or to find not guilty on all. Given that the argument generally being we didn't prove there were victims, I think that's definitely false. Children, specific children were referred to, 5 of them by my count are R, S, D, G, G, M, G, and K, S were the specific children that we referred to during the course of the trial.
Ms. Jenkins, if you go with the initials one more time, I have S, D, G, G, M, G,
K, S, and R, R.
Thank you.
So we have a total of 5 children that we identified with specificity, but I'll point to the testimony of Ms. Werner, who said there were about 20 students in her classroom, many of whom were in her field of vision at the moment that she was shot, and I would propose that it is up to the jury whether they believe more or fewer victims exist of this crime, and so we believe we should not be required to name specific victims in either the instructions or the indictments. The argument that we did not prove age begins with a reminder of 2 things, and of course the court is aware the burden of proof at this stage is the light most favorable to the Commonwealth, but I think more importantly that circumstantial evidence is evidence. We had testimony from several parents who said that they dropped their first grader off at school, that their child was in first grade, and that they were in Ms. Werner's class. Ms. Werner testified that first graders are about 6 years old. And throughout this trial, we've instructed witnesses on the record to refer to people under the age of 18 using initials, and you've had several parents come in and testify using only the initials of their own children. The overwhelming evidence then is that these children were under the age of 18. No, we don't have all of their specific ages, but they were first graders in Ms. Werner's class, and they were students attending an elementary school. And so I think that the proof of age has been sufficient to survive the motion to strike. There were 2 legal standards mentioned by defense counsel in his argument to the court. And one was that he indicated that we had failed to prove that the defendant knew of the danger. But if you consult the model jury instructions, that is not the standard. The model jury instruction for criminal negligence tells us that to constitute criminal negligence, the Commonwealth must show that the defendant either knew or should have known that the probable result of his or her acts or omissions would be serious injury or death to a child. Given that, the correct standard for the court to apply is not that Dr. Parker knew there was a danger necessarily, but that she should have known of the danger. Having said that, she did know. There were multiple warnings she received from multiple people that there was an armed student. And as I argued during the trial on several objections, whether they thought it was a toy, whether they thought it was a knife, whether they thought just the mere fact that a possible weapon is on campus should have triggered the response defined in the crisis management plan, yet it did not. So it should have known and not known. The second legal standard defense counsel left out is from the willful act definition jury instruction. And so the model on that says a willful act is done with bad purpose. That's what defense counsel pointed out, but it's with bad purpose or without justifiable excuse. And I would argue that that is the part that we rely on here. I do not argue that Dr. Parker had a bad purpose. I will concede that fact. But the law says it's either of those, a bad purpose or without justifiable excuse. And I certainly do believe the evidence has shown that she willfully omitted acts that she should have done, and that she had no justifiable excuse for that willful omission. And given that, Judge, I ask you to deny the motions to strike.
Thank you, sir. This is the defense motion, so they can have the last word. Anything additional?
I just want the court to keep in the forefront, again, the actions of everybody. Nobody acted as if there was an actual firearm. Not following school policy doesn't result in a criminal allegation. There were acts that should have been done, definitely in hindsight, but based upon information that Dr. Parker had, she did not willfully take any action, or if there was no willful omission on her part, she put these children in harm. Again, mistakes occurred, but there was definitely no criminal intent. And I would submit that her actions were not criminal. It was just that at the most it was a lapse of judgment. Somebody makes a mistake, that should not result in felony allegations or definitely felony convictions. So omitting a step in a school policy should not be considered to be a crime. She acted upon the information that she had. She took the steps that she thought were necessary. She did not believe that there was a gun. Nobody that was there acted as if they believed that there was a gun. And I'd ask that you find that Commonwealth, even at this stage, in light most favorable to the Commonwealth, has not established a willful act or omission. And definitely the Commonwealth, I think, is conceding that there has been no specific proof of the age of any child that was in that classroom.
All right. There's the argument for and against and for again.
Anything further before the court makes a
For the motion to strike.
No, Your Honor.
I will be honest, we could have done that yesterday. I expected a more substantial motion with case law
There was no
and
case.
additional principles of law that the court would probably need to recess and consider, but we are where we are. Having considered this case for 4 days and listened to the motions of counsel, and the division of labor in a criminal jury trial. So in that division of labor, in those legal proceedings, questions of facts go to the jury, questions of law go to the judge. A question of fact asks what happened, and it requires evaluating evidence such as the witness testimony and or physical proof. Questions of law ask how does the law apply to those facts, and requires interpretation of statutes, precedents, and constitutional rules. And that's kind of legalese, but breaking it down. The judge decides the question of law, which is what law applies, procedure, and runs the courtroom. In this case, a criminal jury, the jury would decide the facts, which is what happened. To give an analogy, because this case doesn't put itself well to analogy, somebody is given a ticket for speeding 70 and a 65, but they're stopped in a parking lot. The jury decides the question of fact. Was that driver actually going 70? The judge would decide, does the speeding law apply in the parking lot? So that's the way to wrap your mind around the difference between question of law and fact, which can get quite convoluted. With the question of facts being resolved by the trier of fact, which in this case is the jury, and their job would be to weigh the strength of the evidence and the credibility of the witness, and judges resolve the questions of law. And what would be put to the jury in this case was whether or not Ebony Parker is guilty, and that would be the question of fact. I do say all this because the distinction between law and fact can become convoluted, and they can be mixed. It can be a mixed question of law and fact. The Supreme Court itself has acknowledged that it can be an imperfect science of where is that dividing line, but identifying that line is important, critically important, whether or not it's a question of law or fact. Question of fact goes to the jury, they make the decisions. Question of law, it stays with the judge. And I guess for purposes of the party's understanding, that influences the courtroom decision maker, the appellate review, how evidentiary rules are administered, and the application of precedent. Which I would say there is no precedent for what's before the court of an administrator being criminally charged and tried for what has been presented and what happened that day, January 6, 2023, at Richneck Elementary School in Newport News. This court is finding that it is presented with a question of law, which requires resolution by the decision maker. The decision maker on questions of law are the judge, and whose decision is that, and my decision is that this is a matter for the court, and the court is of the legal opinion that this is not a crime, not under the common law of Virginia, nor under the code of Virginia.
It's not a
and
crime.
the court is going to explain its rationale and ruling. With that being said, if it's not a crime under the common law nor under the Code of Virginia,
She's dismissed.
should the legislature wish to make it a crime, then they will create specific statutory language to do so. When reviewing the statutory language, the court is bound by the plain meaning of that language and must give effect to the legislature's intention as expressed by the language used. And unless a literal interpretation of the language will result in manifest absurdity. So now I look at the statute. Virginia Code 18.2, 371.1. What the indictment charges here is under paragraph B of that statute. It reads, any parent, guardian, or other person responsible for the care of a child under the age of 18 whose willful act or omission in the care of such child was so gross, wanton, and culpable as to show reckless disregard for human life is guilty of a Class 6 felony. The indictments in this case don't address specific individuals, but they list students. The court finds that what has been presented to it is a mashup of legal theory.
Wow.
And it is not clear, based upon the plain meaning of the statute, that these facts are crimes.
Okay, we're going to pause for just a second.
The court is asking, is the crime that Ebony Parker didn't follow municipal policy and procedure, of which was put into evidence, which would have required two people to search the person of JT.
We're going to pause for just a second. I'm sorry. This is, first of all, it's really hard to hear. I've cranked this up about 20 decibels. The judge just ruled and said there's two, there's a division of labor here. The jury is a trier of facts, and I'm the trier of the law. I find this falls to me in this. There's no precedent to this. I don't have history. I can go back and say, what did other judges say in this case where we've got an administrator charged in a school shooting? And she says, basically, I find that it's not illegal, that there was no crime committed. And she read the law. I think she put a little emphasis on the wanton disregard for the lives of students, the reckless, way that the behavior. There has to be an act that shows that happened. She's saying she did not find it there. So she's now continuing her definitions and her explanation here.
Administrators, or one administrator and one security officer, of which the security officer was on site at a different school performing their duties, and the principal, the other administrator present that's known in this proceeding, was in scheduled meetings during testing. Is the crime that Dr. Parker didn't direct a search of the child's person after being informed that the book bag was clear? Are the 8 counts of the indictment based upon the number of children in the room when the firearm went off? Are the 8 counts of the indictment based upon unfired bullets remaining in the firearm, which would be contrary to established case law as they have to be discharged? Is the delayed reunification the reckless disregard for human life? Is it the emotional trauma of the exposed child who was in the classroom? I believe the initials were KS. Is that the reckless disregard for human life? Is it the fearfulness, bedwetting, and hypervigilance of all the children in the school that day that comprises the reckless disregard for human life? Is it because JT wasn't expelled prior to January 6, 2023 due to his previous behaviors, which presumably would be in the province of the prior principals, Dr. Goodman and then Ms. Foster? Or is the crime the lack of heightened response from Ebony Parker due to her awareness of prior issues with JT? The court is unclear. And as previously stated, those legal theories do not fit the plain meaning of the statute. If they are to amount to a crime, then the legislature will need to codify it. Therefore, I do grant defense motion to strike in whole on all 8 counts of felony child abuse and endangerment under indictment CR, the indictment number 24999-541-01 through 08. So those matters are dismissed. I want to add, my ruling today is based upon legal principles only. It is inappropriate for me to give my personal thoughts or express sympathy or concern, but it's understanding what happened that day was awful, that was agreed upon by all. The criminal matter before me does not call for me to discuss the Newport News school system or make political observations, and I will not comment on optics or engage in speculation. For the media, who has contacted this court constantly over the past 2 weeks, there will be no further comment from this court, except to commend the attorneys on both sides, Mr. Jenkins, Mr. Rogers, and Mr. Teague, for zealously advocating their respective positions and treating this forum with the utmost decorum. It is 9:46, and I did not have the jurors reporting until 10. So I'll ask the parties how they wish for me to discharge the jurors, if they want me to just tell them when they report to the room or have them brought out and do it on the record. But in discharging them, I will remind them that no one from this court will contact them and direct them about this case. And I will ask the attorneys to please inform all of the witnesses that were to remain constructively sequestered that they are released. So from the attorneys, how would you like me to inform the jurors who are still coming in the building that they're discharged from their duties for this case?
Your Honor, I feel like we should discharge them on the record, but I would have no objection at all if the defendant or other parties wanted to leave and just do that with counsel.
Just counsel only?
That would be fine.
Okay, defense position?
Your Honor, I'm actually okay with the counsel's position.
Okay, so I will step off the bench, so we'll be in recess, and then we'll discharge the jurors on the record once they all report. And parties, please be quiet, and however you feel about the court's ruling, you can express that outside of the courtroom. This is still a professional legal forum. All right. Thank you very much. And Sheriff, come get me when they're all reported. Thank you.
Please rise.
All right. With all 8 charges dismissed, there's nothing hanging over Ebony Parker's head now. The judge says, I did not find the crime. There was no crime. We have nothing to charge here. There was no offense. If there should have been an offense, she says this is the fault of the legislature for not putting that in place. But it's not there right now. And she said, I'm not going to make any further comments to the media or anyone else other than to thank both sides. You did a great job. Obviously, defense is thrilled right now. This is the best possible outcome, other than possibly having the case dismissed before trial. This is the best possible outcome. The judge says it's not even worth wasting the jury's time because they can't find her guilty when a crime did not actually occur.
We can mute the speakers.
All right, we'll mute the speakers. Actually, those are the microphones that we mute. We can turn off the speakers, but that's the way it goes. Here's where a bunch of you asked my opinion on this. First of all, I agree with the judge. This is a terrible situation. It should never happen. There's a lot of fingers to be pointed all over the place. I don't have the facts enough to be one of the people pointing the fingers. I don't know if if there was failure on the parents' part. Obviously, there was a legal decision that there was, but I don't have personal knowledge of that. I don't know if there was failure on the school's part. I know it looks like they did a lot of things to help JT as he had many problems in the school system. Was that too much? Was that too little? I don't know. I will say that I think this lies squarely in the court system and should be in the court system in the civil arena. I think all the parents' lawsuits against the school, those are appropriate. The civil damages, the monetary damages that are sought and sometimes given when they find culpability, liability, That's what makes changes. That's what changes policies. That gets, laws enacted and things like that. But the rush to say someone has to be locked up because this terrible thing happened, I think that's too much. I think that's too much. I do believe there's responsibility. I personally believe that the vice principal should have done something. According to policy, she should have done something. And as a parent who at times used the public school system or grew up in it myself, the school is responsible for a child, and there's a burden they carry that they even take it away from the parents briefly in some aspects, as they are, custodians of the children during the day. There's a burden to keep them safe, and it's almost a contractual burden there that it's compulsory education, right? In most states, you're required to go to school, either at home or public. And if it's required and you are doing it, I think you have to protect those students, or at least care for them, have plan to protect. Even if you can't plan for everything, I mean, how do you plan for a meteor strike in the school? You can't, right? We're not expecting that. But when you do have signs that something is going wrong, and there are plans in place, and you don't follow them, that's where the civil court is the right place to take it. It's tragic that an injury happened here, and it's tragic that the 6-year-old kids and older and younger, we've got kindergarten class that's younger than this group, and second graders and everything that were exposed as well, that they are going through the after effects of surviving this event. The sounds, the things they heard, the stories, the panic they witnessed in adults and everything else, that takes a lot to get over. And I think the civil court is where that case should be fought. On this one, I'm going to say I agree with the judge. Where the way the law is written, I don't believe there was a crime. But I do believe that there will be a lot of civil lawsuits that have big awards going to parents and children that were involved in this, and I think that's also right. All right, we've got calls coming in. Let's see here, just 1 second.
Call from Angela.
Hey, Angela, this is Scott. How are you doing? Long time no talk.
Hello. I'm doing good. You?
I'm doing well.
Yeah. Wow. What happened? Wow. I mean, I am not happy with the decision, but I kind of understand why. Because there is no law.
Right. And I'm okay with the legislature making that a law. I'm not against that at all. I'm okay with the legislature saying this is a law that if you're in this position, you legally have to do this. There's a legal burden you carry. And if you don't do it, it's because it's voluntary. We're not forcing anyone to be the assistant principal here, right? If you don't do it, then there is criminal punishment. I'm okay with that, but the legislature has to step up to do that. And I think they sort of overreached a little bit with the law that didn't quite support what they were going for.
I agree. I'm not happy, but I agree with. I'm not happy with how it descended, but I do agree that something has to be done with it, because there are way too many things like this that happened, and no one is stepping in to stop it, prevent it. Especially people who, like in this case, people came to her and told her, this is a problem, you have to do something about it, and she practically ignored it, did nothing about it. And that's why I think, I hope sincerely that she never, ever, ever gets to work in the school system again, because she is a walking liability and danger to anyone, not just kids, to anyone, and every single person.
I disagree with
in
that,
school.
because there's been no criminal finding against her. That would be enforcing punishment for someone who has committed no crime.
Well, I don't know. Well, thankfully, I'm not the one who decides to let her not see.
Now, if I was a parent, I would have I would make a decision whether or not I wanted my kids to go to a school where she worked, with the information I have. I think that's very appropriate for a parent to make a decision, and I wouldn't judge them for a second if they said, "Nuh-uh, not my kid, not there." I'm okay with that.
Yeah. But I do know that people, I saw it earlier in the comments, that people do agree with me that she should not work in the house. But it's like 50-50 or 75-25, depends on last time I checked the comments. I don't know how it looks now because I'm not by my computer. But I found something, I think, I do not want to quote the wrong lawyers. I'm not going to say who said this, but one of the law tubers said this during the civil trial and after the verdict came in, and how she has to pay $10 million to the teacher. And so one of the things they said is if she is found liable, right now she has insurance or something that actually those $10 million will not come out of her own pocket because as an employee of the state or the county will be paying those $10 million. But if she's found guilty in the criminal trial, then county will not step in and pay those $10 million. So one huge mistake that the defense lawyers asked all of those parents is like to ask them about the civil lawsuit they brought against Mrs. Parker and probably others. I don't know who else is involved, but one of them is Mrs. Parker.
All the teachers, including the one that got shot. I think they're all named. Yeah.
Yeah.
They're all named as
defendants. Is that, I mean, it is not in their interest to pay it's wrong because I think they well consulted, like, this is the chances. If she's convicted, county pays you. If she pays you, but if she's not convicted, county pays you. And it's like, I'm pretty sure even Mrs. Parker's lawyer knows that. So why those questions? I don't understand that. It's in common. Why?
I'm not sure if that's the case. That if she's convicted, then basically the insurance that she's covered under wouldn't pay out. I don't know if that's true, because there is some like umbrella type policies that are put in place for a lot of people. A lot of them are purchased by unions and things like that. I don't know the facts of this case, how it works out in Virginia. It's probable that she would be dropped from her insurance regardless of whether she's convicted or not, because there will be a payout. She doesn't have the money to pay. I bet not even one of the lawsuits that she loses. The only way those families get paid is if the county pays. They're the only one with the pockets deep enough to do it. They're the only ones with access to the state coffers, through, the budgets and everything else. That's the only way they get paid. So if her being convicted would have made her solely liable for that, I mean, you can't squeeze pennies from a rock and water from a rock. It just doesn't happen. And so no one would have gotten paid in that one. So yeah. I'm actually okay with this happening, because if there is a problem, at a school district level or a county level or even a state level, institution level, that group paying would make it, it would drive forward the change. It would make the changes that are necessary. Blood from a stone. That's the quote I was trying to get. Water from a rock. Pennies from a rock. Fran, thank you.
Yeah. Okay, thank you so much. And I just want to give you an update in regard to the competition I went to work. U.S. got 4 medals. So it was good for the U.S. They sent 4 contestants, came back with 4 medals. I don't remember how many gold, how many bronze, and how many silver, but all in all, 4 medals. Also, speaking of that, I got to talk to Bending Spoons company that owns the our favorite StreamYard. Unfortunately, people who were there do not work on StreamYard. They work on some other programs. By the way, that company has like 100 different programs, and they use like half of them or a whole lot of them, even though we don't know that the StreamYard and those programs are basically from the same company. And they told me basically for you to contact the customer service.
The email. Yeah. Great.
Yeah.
Great.
Sorry, I couldn't help more.
I appreciate you trying. Angela, it's great. I'm glad that the U.S. represented over there. Glad you had some fun, and thanks for going to bat for us with StreamYard. So I appreciate it. Thanks for the call, Angela.
I use also StreamYard, so it's not just for you.
I know. It's for us, for all of us, collectively.
Yeah.
Thank you very much.
Yes.
Appreciate it. We'll see you.
Thank you. Bye-bye.
Bye. All right. Wow. Interesting. I want to hear some legal breakdowns of this. I can't wait for some of the lawyers we know, both the lawyer you know, and maybe even Ian on this one. Kurt, I've seen him in chat here a little bit. He's got ties to Virginia as well. Understand the law specific to that state and how this ruling went down. I will say that I was rather critical of the judge on day one. Day one was terrible for her. I'm not backing down from that. She made some just I would say disgustingly wrong decisions. Absurdly wrong might be a better word. But she did change and started and basically changed. I don't know if she just got more comfortable and was listening more to the legal argument, not rushing to a judgment, but she did better. Peter's on it live. We might portal to Peter. That might be fun. Let's do that. It's covering it. It's covering at 3:30. Live at 3. That's a little bit far off. The purple lipstick. That's a look. Saw a couple looks in court. Let's look. I'd say, hey, if you like it, rock it. Looks great. I have been feeling the money should they pay out will be spent by the parents for their own enjoyment. I don't know the individual families, but there's a good bet that the $10 million is not going into a trust fund for a 10-year-old. Should they get $10 million, I don't know what it would be, but Peter in 3 hours. That's going to be awesome. I could pull it off. The closest I do to the purple lipstick is I get those robin's egg candies. They're not actually robin's eggs, spoiler alert, but they've got I guess it's like an Easter time candy because I can never find it other than Easter time. And you eat a few of those and your lips turn colors. Usually white because I like the white ones best, but they're malted like Whoppers on the inside. We can call it an early day. We can do that. I'm okay with doing that. That would allow me to trim all the hedges around my house. And I have a lot. I found pictures. Red wants lunch. Red should get lunch. Let's get Red lunch. That works. Oh, well, Red, do you need us to get you lunch? Those are my favorite Easter candy, the robin's eggs. Yes, they're good. I like speckled eggs rock. They're delicious. That's why you have kids. Please call it an early day. I'm hungry. I am as well. We can portal at 3:30 Mountain. I don't think we can portal to anybody that's going to start anytime soon. But I would like to see it. I think Peter. Let me put this out. First of all, what I know about Peter, he's big on criminal defense, right? And he's big about giving his opinion. I don't think he's going to shy away from that one in this case at all, even though it is a hot topic case involving firearms and public schools, both hot topics in the U.S. I think he's going to side with the judge on this one. And I can't wait to hear what he says. But what about tomorrow? I'm going to the cinema tomorrow around this time. Peanut butter cups are good as well. People are hangry. Can you put a link to his channel? Yeah, we'll portal to it. I can do that. Even though he's not starting for a little while. Okay. All right, we've got a portal set up. We'll jump right to it when this one's done. And then you can hit the subscribe button, first of all, for Peter, if you haven't already, and definitely like the video. And you don't have to give a shout-out to the channel, but do represent us well over there. They've got some great people. Peter's incredible. We've been on the show with him a little bit, and he's one of the good ones, the pillars of law tube, as we like to say. So what happened in Boyd's court with sentencing? I don't know. I haven't even had the time to track it. Who are some of the bad ones? It's a shorter list, but there is a list. I can't say greeners. Peter covered the civil. That's awesome. Runkle's a good one too. Runkle's a good one. Peter does great streams, does great work, for sure. All right, let's go to lunch. It's time. It's time to eat. Thank you very much, everybody. Thanks for first of all, thanks to the mods. They worked overtime to keep the breaking news that happened early this morning about the judge dismissing the case from chat as best they could. Thanks y'all for being good and not spoiling it. For those of you that did accidentally spoil it and got a one-day timeout, tomorrow's a new day. No hard feelings. Welcome back. We love y'all. Just don't do it next time. It's not Foliage Friday. You can't trim the bushes. I have to. We need to take pictures of the house. So anyway, I don't know if we're coming back. I now have to do some homework. This case was supposed to go a little bit longer, and we did not have anything for the afternoon. So we'll look around. If there are some cases you see that you think we should cover, do send a quick note to the burner phone. We'll try to do what we can to research it out. But mods, thank you very much for your great work. I know this was a lot of work today, but you did phenomenal. Love y'all. Thank you very much. Tonight when you go home, please hug the people you love, smile at someone, make their day a little bit better. Please stay safe till we go live again, whenever that may be, either today or tomorrow morning, because Josh says there might be a little something for us. We're going live tonight at podcast on Thursday, 8 p.m. Tonight. Be here, 8 p.m. That's going to be a lot of fun. We've got some fun stories, and some that we might not cover as well. There's some crazy stories this week in the news, like really, really crazy. And we're going to try to weed out the ones that are just too crazy for the channel. But see you guys tonight at 8 p.m., if not sooner. All right, be good to all. Bye. I said be good to all. Be good to each other. Bye-bye.
Don't miss the forest for the trees.
Somebody just sent me a video of roaches fighting. I don't know who won.
Because he's the guy.